Good afternoon, and welcome to the Appellate Division First Department. Today, we have over 8 hours of oral argument time requested. So as I call the calendar today, please only request the time, not that you want, but that you need to make your most salient arguments. And you already know, but I will repeat it, that we have read your briefs and are familiar with the familiar issues of your appeals. Now, for those of us who may be here for the first time, the white light on the lectern will go off when you have 2 minutes remaining, or if you've requested less than 2 minutes, it will go on immediately. When the light turns red, that means your time is up. Not for us. We may have more questions. We'll see what happens. Now, if the panel has further questions past your allotted time, certainly we will continue to pose questions, and you will certainly have the opportunity to respond. So when I call your case, please rise and tell us who you represent and how much time you are requesting. First case, People v. Almodovar.
Your Honor, appellant requests 6 minutes for the main argument and 1 minute for rebuttal.
Okay.
Respondent, 4 minutes, Your Honor.
514. Hess versus Zurkin. Uh-huh.
Good afternoon, Your Honor. Respondent requests 4 minutes.
All right. With the repellent, I don't recall requesting rebuttal. 4-4. CV Children submitted. Contreras versus City of New York. Mm-hmm. All right. 5-2. Anderson versus AAC Cross County Mall. Mm-hmm. 4-4. People v. Michael Ortiz. Submitted. People v. Renell Dortal. Submitted. Priority Management versus Deutsch. All right. Well, certainly you're not going to argue against yourself. Can you remain standing? Would you like to submit? Okay. Submitted. Thank you. Yes. Yes. Does anyone have any questions? No questions. Okay, thank you. DLJ Mortgage Capital versus Atla. Submitted. Is it the cold weather? New York State Unified Court System versus New York State Public Employees Relations Board.
Good afternoon, Your Honor.
Okay. Uh-huh. Okay. 5-2. Oh, I apologize. Okay. 5-2. Thank you. 1-2. Gotcha. 1-2. Got it. Thank you. Okay. H Children. Submitted. If I mispronounce the name, my apologies, and just correct me. Isaac versus Briarwood Insurance? Uh-huh. Okay. 5-5. People versus Dominique Johnson. Submitted. People v. Holcomb is submitted. Panstar Realty versus New York Teachers Housing. Okay. All right, 5-5, thank you. People v. Sharon Porter. Mm-hmm. 5-5. Brenis versus City of New York. You said? No need to apologize. 5-3, thank you. Carvello versus Warner Music Group, and this is 2025-01283.
Good afternoon, Your Honor. For the appellant, 5 and 2, please. I'll be introducing my partner to be conducting the oral argument.
Okay.
Good afternoon, Justice Kennedy. For respondent, 5.
All right, 5-5, thank you. The companion, Carvello versus Warner Music Group, 2025-01516.
Good afternoon, Your Honor. Respectfully request on behalf of appellant 6 and 3.
Mm-hmm.
Good afternoon, Your Honor. Again, for the respondent, 5.
All right. 5-5, thank you. People v. Worrell. Submitted. Board of Managers versus 56 and Park.
Good afternoon, Your Honor. For appellants 5 and 7. Respondent 56 and Park, New York Order, request 5 minutes.
Mm-hmm.
Respondent King Spence's 5 minutes. Respondent WSP 5 minutes.
All right. 5-3, 5-5-5. Thank you. People v. Williams. Submitted. Peralt versus Bloomberg LP is also submitted. First case on the calendar, People v. Almodovar.
Good afternoon, Your Honors. May it please the court, my name is Arthur Hopkirk. I represent Jose Almodovar. Mr. Almodovar was a hardworking 53-year-old family man who had never been convicted of a violent crime before when he fatally stabbed Mr. Almonte during a dispute at the Jeep dealership where he worked. Neither the goals of public safety nor of deterrence are advanced by Mr. Almodovar's 15-year sentence.
Counsel, if I may, you know, this is a situation where your client, it was, you know, initially a dispute over a parking space. And, you know, these two coworkers agreed to fight afterwards. I think there was a 30-year difference between your client and the decedent, and then came back to the location with a knife. The decedent wasn't armed, stabbed multiple times around the neck, torso, and then hid the knife. Certainly, we are not making light of your client's difficult situation. But it seems to me that the court took all of that into consideration by giving your client 15 years with 5 years post-release supervision, although the decedent's family was opposed to it.
Okay. Certainly, as I said, the crime was not justified. However, this court has an independent obligation to review sentences, and certainly in this case, I understand the decedent's family's understandable opposition, but this court has, in past cases, certainly reduced sentences even when there's strong opposition to the sentence that was originally imposed.
Counsel, your client faced how many years on the murder second-degree charged?
25 to life, Your Honor. However,
And he was offered 15 years.
yes, Your Honor.
And that was taking into consideration all of the mitigating factors that you've mentioned. His age, the fact that it was his first arrest, that he expressed remorse, all of that. And that was despite the strong objection from the decedent's family, from the complainant's family, the victim's family. And now you're asking us, and on top of that, he also waived his right to appeal, which precludes our review of his excessive sentence in case that you were to argue that the sentence was excessive. So now you come to us so that we reduce it even further in the interest of justice?
Yes, Your Honor, and obviously we discussed in our briefs why we think the waiver of the right to appeal wasn't enforceable and valid here. But I think it's important to note that the district attorney expressed considerable doubt about whether they would be able to prove intent to kill at trial, and so I would say—
Well, that was only in because the judge did not want to accept the 15 years, right? The judge was like, "What do you mean 15 years?"
the first judge,
Right? The first
Justice
judge, and
Fabrizio.
so that's where the district attorney said, "Well, Judge, here's why we're doing that." So that was in response to a court's view that the plea should not have been for 15 years. This was a 22-year-old man that your client killed, correct?
Correct.
And your client was 50. And your client, this was not his first arrest. This was just his first violent felony, right?
Correct, although he had been crime-free for 20-some years.
Right. And so here's a person who one would think would have the maturity not to come to a fist fight and stab someone to death, right?
Well, I think the correct way of looking at that is, as we discussed, as is discussed in the pre-pleading memo and the neuropsychologist's report, that because of Mr. Almodovar's history of childhood abuse and trauma, he may, and his anxiety disorders, that he may respond to stressful situations in a different way than the typical person would.
Thank you, counsel. You'll have time on rebuttal. Thank you.
Good afternoon, Aiden Sanchez for the people. Your Honors, I would reiterate everything that has been said by the court and say that a sentence
Counsel,
reduction.
with regard to the waiver of his appeal rights, as I recall, the pre-sentence report indicated that Mr. Almodovar had serious intellectual limitations. I didn't see any indication in the record that the sentence court adjusted its discussion of appeal rights to take into account Mr. Almodovar's limitations. Was there any significant attempt by the court to phrase that lengthy discussion in simpler terms, given Mr. Almodovar's limitations?
Yes, Your Honor. So first, I would just point out the limitations that were described in this report. I would not use the word substantial. Even in the report, this doctor describes Mr. Almodovar's mental capacity or limitations as mild at best. But to answer your question, the court fulfilled its duty by taking time when the defendant stated or indicated that he did not understand something that the court said. The court fulfilled its duty by stopping the proceedings and giving time to defendant to confer with his counsel in tandem with the Spanish interpreter that was present at the proceedings. And in fact, the defendant here did on numerous occasions state he did not understand the question, and the court gave him that time. And then defendant stated that he did understand, and the proceedings continued. So there was no special hand-holding that the court engaged in. However, it did give the defendant opportunities to manifest these cognitive limitations by his counsel stating, can you please repeat the question or reiterate the question? Those opportunities were presented, but defendant did not take advantage of those moments at the proceedings.
Counsel, how do you respond to your adversary's argument that because the defendant is 54, there's no or very little chance that he will commit another crime?
I mean, that may be true, Your Honor. That age obviously correlates to a defendant's future possibility of committing crimes, but the severity of this crime should not be understated at all. The
So
decedent
you're saying that punishment is part of the equation, not just deterrence and rehabilitation, it's also punishment.
It is part of the equation, Your Honor, yes. And this was a severe crime. The defendant in this case, as Your Honors mentioned, stabbed a 20-year-old decedent multiple times, causing his death, ostensibly because of a dispute that the two had regarding their job duties. The defendant indicated, or when the two had spoken to each other and it was clear that they were going to, take this outside to fight, the defendant grabbed a knife with him and took it to what should have been, a fist fight, and this 20-year-old victim ended up dying because of that. So punishment is part of the equation, of course, as is deterrence for future crimes, but this was a very serious crime. And the court...
When you describe this as a dispute over a parking space or something like that, it seems to me, I'm not sure you're taking into account Mr. Almodovar's statements that the victim had threatened him and had bullied him repeatedly before that. Are you taking that into account in the seriousness of the crime?
Yes, Your Honor. Although those, some of the statements of how the fight initially occurred it's unclear from the record because there were some witnesses that were not able to be brought into this case. But that does not excuse the fact that this defendant preemptively brought a knife to this disagreement, this dispute that he had with a younger coworker, and all of this is over their job duty, something that did not need to become physical to be settled. So this defendant not only engaged in a physical dispute over their job duties, but took it a step further by bringing a dangerous weapon to that fight. And as Your Honors have noted, the court during the plea proceedings did take all of the defendant's mitigation into account. It read the pre-pleading memorandum which outlines all of the mitigation that defense raises today. His family support, his childhood trauma, and these cognitive difficulties that he had were all presented to the plea court. And the court read and considered those mitigating factors, but did not find them persuasive in giving a lower sentence than 15 years.
Thank you.
Thank you.
Just briefly, Your Honors. First of all, going back to Justice Mendez's point that this was originally charged as a murder case, this would certainly not be the first time that this court has reduced sentences for first-degree manslaughter, even when murder in the second degree was the original charge. So I don't think that in itself should be an obstacle. As our client's statements as reflected in the VDF, obviously we have a limited record here, indicate at least his version was that Mr. Almonte threatened to kill him, and that certainly doesn't excuse, and we don't suggest the killing was justified, but I think it is relevant background to what was going on here. Mr. And as we discussed, hypervigilance and reduced emotional self-control and impulsivity are all characteristics that are consistent with somebody who had the rather horrific experiences that Mr. Almodovar had as a child. And so we would respectfully request, I see my time is up, that the sentence of 15 years be substantially reduced to somewhere between the 10 years that was requested by the defense below and what it currently is.
Thank you very much. Hess v. Zurkin. Before we begin, can I see you for a second? Thank you. Oh, I have it from here. Thank you. You may proceed. Thank you.
Good afternoon, Your Honors. Adam Engel on behalf of the appellant Joey Hess. The court below misapplied both the basic motion to dismiss standard and the law controlling the substantive claims at issue.
What about the law of the case doctrine?
The law of the case.
What's it most significant here?
No, the law of the case doctrine doesn't apply here because the facts between the two defendants are significantly different. The allegations against Ms. Zurkin are significantly different than those that were against Mr. Zurkin. And the court below decided this motion on the merits. The court did not decide it on the law of the case. I think that was what the respondents were asking for, but the court did not, in fact, take them up on it. The court walked through the actual substantive elements of the claims, went over the facts again, and decided this motion similarly to the other motion, but based on essentially different facts. And to those facts, the court below misapplied the termination in plaintiff's favor element and ignored the Smith-Harvey case, which is controlling since, I think, 2000. That case went through all of the cases that the court did rely on and essentially repudiated them and said that they had been getting the law wrong all along.
One second, counsel. I'm reading from the court's decision, in which the court said, the court's prior determination that Hess did not sufficiently allege that the criminal proceeding was terminated in her favor is in itself enough to dismiss that cause of action. Of course the court addressed law of the case doctrine. I don't know how you could say she didn't. So let's assume that we disagree with you and think that she did address law of the case. Why is law of the case not applicable?
Because the allegations against the defendant, Samantha Zurkin, were fundamentally different than those.
How are they fundamentally different?
The things that they each told the police were different.
No. On the issue of whether or not it was pled, the criminal proceeding was terminated in her favor, and the issue of whether or not malicious, actual malice was pled. That's what the two grounds were, right? So how are they different between the two parties?
Right. I mean, I suppose they weren't fundamentally different.
Oh, they weren't,
issue,
right? I
It's the
agree.
it's the same decision by the
Right,
by
and
the-
so the prior determination was that on those two elements, with respect to the one defendant, wasn't pled. The same allegations were made with respect to the second defendant. So the law of the case said, and the judge frankly said, I'm not readdressing this. So you didn't appeal, or your client didn't appeal that first decision, correct?
Right.
So where are we now?
So the law of the case doctrine is not a requirement. It's not a legal requirement. The court can decide to apply it or not apply it. And I think here, the court in both instances completely ignored the Smith-Harvey law. I think my client has a perfectly good malicious prosecution claim. She pled that based on the defendant's multiple lies to the police, which are documented in her complaint, that there was, that the case was terminated in her favor and not in a way inconsistent with her innocence.
Glad you brought that up, because that's where I was going with you. You know, where in the complaint do you allege facts, you know, indicating that the criminal proceeding was terminated with prejudice? Because you need that.
You need termination with prejudice or in a manner that shows that the prosecution is not going to go forward. And so here, the prosecutors dropped the case after they finally got the evidence. I don't have
How do you show that in the record?
in the complaint, my client alleges, and that's one of the main issues, is that this is on a motion to dismiss based on my client's pleading, and she clearly pleads that when the prosecutors got wind of the fact that the Zurkins had made up the 25 to 50 phone calls, et cetera, that's what caused the prosecutor to drop the case. So once we bring the case and a dispositive motion is filed, my client didn't have an opportunity for any discovery, and she can only rely on her own pleadings.
Thank you, counsel. Thank you.
Thank you.
Good afternoon, Your Honor. Robert G. Lano. I represent the defendant respondent. Our brief shows the top two main points of our response. One, issues that were argued were not preserved for appeal. And number two, law of the case is relevant and does apply. Just to repeat one other subtle point on that, motion to dismiss one by Adam Zurkin, defendant, was granted. And Hess didn't oppose it. She didn't move to re-argue. She did appeal, but she didn't perfect her appeal. So that is stale. Motion to dismiss number two by my client, Samantha Zurkin, was made on the basis of law of the case only. That is the issue before this court. So those are the two main points of our brief. And now briefly to just rebut and respond. Opposing counsel said that the facts are different. Wrong. It was a copy and paste job. The first complaint went on for hundreds of pages with millions of exhibits. We moved to strike that. It was struck out. The amended complaint and second amended complaint were copy and paste. The verbiage was identical, which is why we went for law of the case. It was the same causes of action, the same identical wording, and the foundation is laid for a law of the case argument. He's opposing counsel saying that somehow respondent was asking for a decision on the merits. No, we didn't visit that or revisit it. Key point in Hess's argument is that Samantha Zurkin somehow had a different fact pattern. My client was mentioned by name once in that second amended complaint. Hess did not plead anything directly and specifically as to Samantha Zurkin. So the idea that there's a whole different fact pattern is quite inaccurate. Opposing counsel should have not made that kind of comment to the court at all. It's inaccurate. And she was only mentioned once. Hess had group pleading, which is prohibited. On that whole element, I'll go there, but just on that whole element of the final determination in the criminal court not being inconsistent with innocence, Her Honor held that the pleading was vague. Hess's pleading was vague, conclusory, and speculative. There was never anything mentioned as to how that criminal case really ended. And there should have been details on that if she
The
wanted.
fact that it says that it was dismissed, and there's a certificate of disposition in the record that indicates that the criminal matter was dismissed. So shouldn't we be considering that, or shouldn't that be enough to indicate that it was terminated in her favor, or should we look for something else?
I think the trial court was right in stating that that was too vague. Plaintiff has the duty to plead, and to plead with specific facts. A plaintiff cannot plead with legal conclusions. And the law on motions to dismiss is that a court does not have to accept vague and conclusory pleadings.
Yeah, but now I'll take it a step further, because the certificate of disposition says motion dismissed, motion to dismiss granted.
And that is all, Your Honor. That was all it
So
said.
somebody made a motion and the court accepted that and dismissed the case.
But we don't know what the basis of the motion is. We don't have a holding. We don't have a detailed decision. We don't know what happened. And that is her burden of proof, or burden of pleading. She has to lay that out and tell the civil court why that got dismissed. And she did not do that.
Thank you both. Thank you.
Thank you, Your Honor.
Contreras versus City of New York.
Good afternoon, Your Honors. May it please the court. Michael Taub, the Plata Law Firm for Plaintiff Contreras. The most important point that I can make before this panel is that the fact that Mr. Contreras was on a coffee break at the time of the accident in this department does not preclude the application of Labor Law 240 subsection 1 or 241 subsection 6 in and of itself. That's what the case law says. The Keenan case cited by defendants is a second department case, and it does not apply in this department. It's well documented that this department, the first department, recognizes Article 10 liability under 240 sub 1 and 241 sub 6 under this circumstance, and Justice Cohen in the lower court was correct on that point.
So, counsel, isn't it a fact that there's a case right on point, Hoyos, which talks about what you just said, and that the first department is not in accord with the second department, that if you're on a break, it does come within the ambit of 240?
That's correct, Your Honor. It happens from time to time that this court and the second department or some other department are not in accord. In this court, it applies. The second most important point that I can make before this panel is the fact that the chisel, which fell and struck plaintiff, was not in the process of being hoisted or secured when it fell, also does not preclude Labor Law 240 sub 1 liability.
The issue is really whether or not the action of the chisel was a result of the operation of gravity, which one assumes it was, correct?
Correct, Justice Gessmer. That's exactly right. It applies. This case is different from Narducci, cited by my colleague to my right. Here, the thing that fell was not part of the building. It wasn't a pane of glass that fell from above. It was a tool that was being used, which was integral to the job, if you will, to cite language from the case law, that fell.
Does it matter if that the plaintiff doesn't know how that chisel fell?
It does not. It does not matter at all, Justice Mendez, and the reason why is because, frankly, it fell. There's circumstantial evidence that it was a chisel that hit him. He's sitting there. He's on a coffee break. He feels something hit him in the midsection. defendants make a big point of whether it's the left side or the right side, but as I said, the left side or the right side of his body, I mean. But as I said in my brief at some point, it wasn't.
Is there any testimony that it wasn't a chisel? I mean, everyone agrees it's a chisel,
Yes,
right? The people who were sitting next to him say it's a chisel.
yes.
So, right? So that doesn't seem like an issue that you really need to spend a lot of time on.
The chisel fell from a higher level of a
Question is, the trial court found that there were issues of fact as to whether or not it was properly secured. So that's what, why are there no issues of fact on that issue?
There were no issues of fact on that, Your Honor, because it fell.
If it was secured, it wouldn't have fallen, right? It seems like an a fortiori type of thing.
Exactly. I almost thought that would be a facetious answer, which obviously
But also,
I have
there
no
was
intent.
testimony that the chisels were supposed to be in buckets when they weren't being used, right?
I believe that is in the record
So
also, Your Honor.
there is testimony that it was supposed to be secured when it wasn't in use.
Correct. And it wasn't secured.
Right.
It hit him, and that's about all that a construction worker has to prove.
And what do you say to the testimony that there was, the scaffolds were sufficient because someone testified that there was netting between the scaffold and the wall?
There was netting at some point, but there was not sufficient netting to prevent this from falling. If there was sufficient netting, it wouldn't have fallen.
So, counsel, isn't there a case that we decided not too long ago, Rinson, which you talk about in your papers, where a wrench fell under similar circumstances? Is this the same, or is it distinguishable as how counsel did in his papers?
I don't see how it's distinguishable, Your Honor. It's factually similar. The wrench slipped out of the worker's hand, fell 10 to 15 feet, hit plaintiff, who was working below. He was on a scaffold. The argument that the wrench could not have been functionally employed if it was secured on the parapet wall completely misses the point, because the wrench could have been tethered to the worker. That's a quote from the case. In any event, I see that my time is soon to run out, or actually
It's
it did. I
up.
will.
It's up. But you will have
Thank you.
time. Thank you.
Good afternoon, Your Honors. May it please the court. Jonathan Bartlett for respondents appellants. As my colleague noted, this is a case involving an allegation of a falling object. Now, I'd like to start with a little bit of...
Dispute that there was a falling chisel, do you?
We don't dispute that there's testimony in the record that a chisel was seen on the surface of the sidewalk bridge after it allegedly fell. Nobody personally saw the chisel fall. Nobody, a plaintiff himself testified he did
Well, let's
not.
cut right to the chase. You know, did you present any testimony to contradict that the chisel fell?
We highly dispute plaintiff's account of the mechanics
No.
of the accident.
Let me pose it again.
Sure.
Where in the record can we find evidence that contradicts that there was a fallen chisel? Because all over the record, it's fallen chisel, fallen chisel, fallen chisel. So where can we find?
Plaintiff is the only one.
No,
who
I'm still
testified.
speaking, counsel. I'm still speaking.
Apologies.
So where in the record can we find that it's something different? Because all in the record, fall. So where can we find in the record that contradicts that?
Plaintiff's allegation of a falling chisel is entirely speculative. He saw the chisel on the sidewalk bridge after it fell. His colleague sitting next to him did not see it fell, and he was only a number of feet away. This is an unwitnessed accident, even by plaintiff himself.
Let me pose another question to you, because you rely on Keenan, Second Department, that says, you know, if it happens on a lunch break, you know, it falls outside of the protections of 241. But certainly, this court in Morales rejected that. So my question is, why would we not follow our precedent in Morales?
With all due respect, it's our position that applying the facts of this case, applying 240 given the facts of this case, and given the fact that the plaintiff or nobody else on the job site at the time was performing work under the ambit of 240, would stray too far from the Court of Appeals determination in Martinez.
So you're saying that the fact that plaintiff was on a short coffee break, that in and of itself takes him out of the protections of the labor law?
The fact that it was a site-wide designated coffee break during which neither plaintiff nor anybody else at the site was performing construction work. No work under 240 or 241
For
was being
that
performed.
15 minutes, you think that we should not apply the labor law to that 15-minute period? You think that are you arguing that that advances the protections under the labor law? That for 15 minutes, if you're drinking your coffee, that you don't have any labor law protection?
With all respect, we feel that the Court of Appeals was clear in Martinez in stating that the task in which an injured employee was engaged must have been performed during the erection, demolition, et cetera, the work enumerated by the statute. Additionally, the Court of Appeals in Stoneham said that whether
So
the
I
plaintiff-
guess your answer is yes. For that 15 minutes that the worker takes a break, no protection under the labor law, even though they're on the construction site, in the construction site. For that 15 minutes, we suspend the statute?
Well, we feel that in this case, there was no exposure to no potential to exposure to the inordinate
Except he
danger.
got injured, and let's assume that the only evidence in the record was that he was hit by a chisel, and we're required to accept that, right? So even though there was no work going on, the worker got hurt by a falling object, right?
He alleges he did.
Well, let's, in the record, there's testimony from, I believe, Mohammed, who was one of the supervisors, that he was somewhere above from where plaintiff was having his coffee break. He was there inspecting the area.
Correct.
Now, he says, I didn't see anybody either use a chisel, throw a chisel, kick a chisel. But plaintiff said in his testimony that he heard that there were people above him. And then he says, I was struck by a chisel.
Correct, correct, Your Honor. So Mr. Muhammad, who worked for non-party Whitestone, and Mr. Patel, who worked for SCA, were both, I see that my time is almost up, were both performing a visual inspection, one level above plaintiff, which was about 6 feet up. Both of
Thank
them-
you, counsel. Your time is up. Thank you.
Thank you.
Counsel, I have a question. When your friend here said that the fact that he was hit by a chisel was purely speculative, I see at least 3 points in the plaintiff's deposition where he says, a chisel hit me in the back. Is that speculative?
No.
Okay.
Isn't there also a accident report where Muhammad specifically states that the chisel was involved?
Yes, there is, Justice Hagler, that is correct.
And one last question. Your friend had argued that it was a break, but how can it be a break if people were inspecting above the plaintiff? So even if his argument is correct, it's factually an opposite because not everyone was on the break. Apparently, people were above.
That is also correct, Justice Hagler, yes. I'll just close in saying that defendants use the word during in that quote from, I believe it was in Martinez, in a way that was out of context. There's no case law to support defendants' argument. And as I say somewhere in my brief, chisels are not supposed to fall and hurt workers below. And that's why 240 applies. I'll rest on my brief on my arguments on 241-6 and also 200, and as well as the question of whether Justice Cohen properly granted our cross motion or our motion to amend the bill of particulars, which obviously we say he did, and I thank the panel for its time.
Thank you.
Respectfully, I'd like to respond to my colleague and also some of the questions that were posed. Mr. Muhammad testified that when chisels were not in use, they were to be kept in buckets. A bucket is not a 240 safety device, nor does my colleague argue that.
Excuse me, counsel. You're done. You did not request more time.
I requested 10 and 5, respectfully.
No. Thank you. You didn't cross-move. Thank you.
I requested the same as him, respectfully.
Counsel, I'm not going to repeat myself.
I think you gave him 2 minutes.
No, that was,
Oh, you know, I think you might have given him.
Yeah, you gave him 2 minutes.
Yeah.
you know what? I want to apologize. I am humble enough when I make an error. So I made an error.
Apology accepted, Judge.
Okay, thank you. Go ahead.
Okay. Mr. Muhammad and Mr. Patel, who were on the second level of the scaffold, which was one level above plaintiff, approximately 6 feet up, testified that there were no loose tools or chisels on the platform. The work they were performing, again, was a visual inspection. It was not 240 work. The platform levels were clean and clear. Nobody witnessed a chisel falling, and nobody witnessed anybody kick or heard of anybody kicking a chisel.
How many workers were there inspecting the area above?
4, Judge.
How many?
4 total.
And how many testified?
2.
And what about the other 2?
They did not testify.
So we don't know if they saw something or they did something that caused the chisel to fall.
They were on the same level as Muhammad and Patel both testified that nothing fell. Nobody
You
was.
said, I didn't do anything and I didn't see anybody do
He
anything.
said nobody did. Nothing fell, and nobody reported to me that anything fell.
Counsel, can we move to another area?
Yes, please.
You know, how was there any unfair surprise or prejudice? I'm now turning to the cross appeal.
Right.
You know, when plaintiff, you know, always said, you know, the theory of the case was that a chisel fell from above because of, you know, inadequate protection from day one.
Any surprise or prejudice as to what specifically?
The motion to amend.
Oh, okay. Well, we didn't get to the 241 claim yet, but
But I got there.
okay.
I got there.
No, I just mean that our argument is related. So with respect to that, we argue that as both of the industrial codes predicating plaintiff's 241 claim, which both pertain to tow boards, are inapplicable, and we thoroughly rebut them in our papers, the leave to amend the pleading should not be granted. I would just like to conclude by saying that should the court disagree with the arguments in our brief, we contend that there are numerous issues of fact, specifically and most saliently pertaining to plaintiff's credibility in terms of his changing testimony as to the sufficiency and presence of the tow boards and the netting on the scaffold, as well as his allegations as to the mechanics of the accident. There are numerous issues of fact. The record is replete with them, and they should be before a jury in the event that this court is inclined to grant plaintiff's appeal. Thank you very much.
And counsel, again, my apology, okay?
Thank you very much. Apology
Okay.
accepted.
All right, thank you. All right. Anderson versus AAC Cross County Mall, LLC.
Thank you. May it please the court, Lori Parkman for the plaintiff appellant. I know the court is familiar with the records. A storm in progress case where the ice pre-existed the storm, and the court correctly found that. However, the court granted the snow contractor, King Fences, motion for summary judgment, finding that it did not have a duty under Espinal. This was error for numerous reasons. First, it is clear that negligently piling snow up into snow banks that then melts and refreezes is an affirmative act of negligence, which constitutes launching an instrument of harm under Espinal, and that's Prenderville from 2004 in this court.
Who testified that that happened here?
I'm sorry?
Who testified that that happened here?
Well, there's numerous pieces of evidence.
No,
one
wait,
testified
let
they
me
watched
just
it
start
happen.
by your client said nothing going on, no snow on the ground, nothing like that in the parking lot as she's walking through the night before.
The night before, she said there were puddles in the exact area.
But no,
where
you're saying there was something about piles of snow. Where is that from?
The puddles came from the piles of
Who
snow.
testified to that?
Well, plaintiff in her affidavit explains that there were piles of snow. Moreover,
Did you allege that in your bill of particulars?
I'm sorry?
Did you allege that in your bill of particulars?
Yes, that was the first error the court made on this, was the court said that the bill of particulars did not allege affirmative negligence on King's part, which was just incorrect. Page 80 of the bill of particulars, we
And it
alleged,
specifically alleged that, that King was responsible for creating piles of snow that then melted, that created the ice that caused the plaintiff to.
well, by improperly and negligently clearing the accumulated snow. The court
Specific.
focused on the language saying that they hadn't timely done something and said that's not affirmative. We did allege the affirmative, which made it the defendant's burden. But even if it was plaintiff's burden, the bill of particulars is only relevant to who had the burden in the first instance, because the plaintiff can raise a triable issue of fact.
The thing is that I don't see in your bill of particulars that which you claim now that you did allege, that they negligently piled snow. Or am I
I
looking
didn't
at the
say
wrong?
piled snow, Your Honor, that they improperly and negligently cleared the accumulated snow.
Right, so that's the one that's falling at the time, right? That's the snow that is falling at the time
No.
that she has her accident.
No, the accumulated snow, which was prior. They did not clear during the storm. They came whenever there was significant snow, which there was earlier in the week.
Again, that's what I'm trying to figure out. How do you know? Where does it in any place say that King previously came, cleared snow, and created these mounds?
Right. The testimony of both the defendant's witnesses were that King came whenever there was significant snowfall. Those witnesses could not remember exactly when, but
Exactly.
the meteorological evidence showed that there was significant snowfall 3 to 4 days before, with 5.5 inches, and that snow was melting over the next 3 days. The meteorological
Who established that snow from 3 to 4 days before was melting over that 3 to 4 day period?
Yes, that's the meteorological, by the temperatures. Our expert goes through. On the 15th, there was 1 inch melted, 2 inches melted the next day. What's specifically,
No, I'm still talking about, nobody says that the snow company came and 3 or 4 days before made mounds of that snow. No one says that.
well, Mr. Cipriani, their president, he couldn't remember when exactly he came, but he
Exactly.
showed, and he said, yes, that is exactly how we do it. He saw a photo of snow banked up and said, yes, that's how we do it, and we come every time it snows.
This is going to be the last question.
Oh,
I would like to know, how did your client establish that King launched a force or instrument of harm when your client testified that she didn't see any ice in the parking lot on the night before, the snow on the ground did not appear plowed, snowed, salted, or treated with sand before she fell? So how did you prove that they launched a,
right, the court said there was,
force or instrument of harm?
the court said there was no evidence that they did snow removal that morning, which, yes, there wasn't, but the court looked at it too narrowly. The evidence was that they came when there was significant snow. There was significant snow 3 days before, and the meteorological evidence, just my last point, it's very important, there was no precipitation whatsoever the day before the accident. And the plaintiff saw puddles in the exact area. So the meteorological evidence says that those puddles could not have come from any precipitation. There was no precipitation. It had to have come from the melting from the snowbanks. And then after around 4 to 6 p.m., it became freezing, and it was freezing after that. So the new snow that fell starting at 7 a.m. could not have frozen. It could not have melted and refrozen because it was below freezing the entire time.
Couldn't the
Thank you.
puddles? Oh, I'm sorry, go ahead.
My colleague will pose that
Yes,
question
I
to you
will.
on rebuttal.
Yeah.
Good afternoon. May it please the court, my name is Lauren Donnelly, and I represent the respondent, King's Fences. King's did not launch an instrument of force or an instrument of harm.
Was King's responsible for clearing puddles of melted snow in the parking lot? Was that its contractual duty?
No, they were contractually obligated to treat after a snowstorm, not, and only come when they were called by AAC.
And assuming that it had snowed 4 days before and the snow just melted, that it wasn't scooped up, it just melted, the same puddles would be there, right?
Yes, but you have to understand, this whole snowbank theory is a feigned issue of fact. The plaintiff testified at her deposition that obviously there was no plowing done that time, but she also said that there were no snow piles anywhere in that area. The photographs that
So then, and then later on, she said, oops, I misspoke. There were in an affidavit,
Yes, and that
which directly contradicted her
Right.
deposition
and
testimony.
is insufficient to raise any triable issue of fact. In terms of the other, the witness, the affidavit of Ms. Whitaker, this also goes to the defense of a storm in progress. So either under Espinal, the court should affirm, or under the storm in progress rule. It's undisputed that this was snowing at the time. Everybody confirms that. Plaintiff, the subsequent witnesses who came afterwards, and both experts say that there was a storm in progress at the time, and there was no duty to remediate any snow during the course of that. The expert affidavit lacked any evidentiary support. There was no foundation. They reviewed records. There were photographs of an area where plaintiff did not fall. So it's speculative, insufficient to raise any triable issue of fact. For these reasons, I'll rest on my brief unless there's any other questions from the court. Thank you.
Hi, thank you. I'd just like to start saying, when she talks about plaintiff's testimony, there is a bit of confusion in this record because the photographs which plaintiff and which Mr. Cipriani viewed during their depositions are not in the record. The photographs in the record are from the owner's deposition, and they're not the same. Plaintiff reviewed 1 or 2 dozen photographs, and
Well, we can't speak about them, though, if they're
right,
not.
but their arguments, when you look, they're trying to cite to photographs that are not the photographs and saying
Counsel,
she said there was nothing
Can
near
I
the
direct you
fence.
to the snowbanks question?
Sorry?
Was there deposition testimony by the plaintiff wherein she testified there was no snow in the area the night before?
She said there were puddles in the exact area.
But did she testify there was no snow specifically?
In the exact area where she fell? No, they were banked up. She didn't testify to the banked up, but she was testifying about
No,
the
she
exact
didn't
area
say
where
anything
she
about
slipped
banked up.
had puddles.
Counsel, she said nothing about, she said there was no snow. There was no snow in the area, right? Not there was snow banked up over here, but not there. She said there was no snow in the parking lot as she was walking home the night before.
I would just like to emphasize that their own witness said they plowed up into banks, and also the meteorological evidence, it's not speculative, it's based on the science of the weather, that there was no precipitation the day before. Where did these puddles come from? The fact that these puddles were there and had to have come from melted snow itself is evidence, and all of this evidence has to be viewed in the light most favorable to the plaintiff with every inference. And that's a classic circumstantial inference. There's water there. Where did it come from? Well, it could not have come from rain. It had to have come from the snowbanks.
But that doesn't connect to, and it was piled up negligently by the snow removal.
The photograph that Mr. Cipriani, he said that is how we piled it up. He admitted that they piled it up, and he admitted that it would
As a general matter,
And
right? They piled up snow as a general matter.
It was that. That's another thing about the photographs, where they try to make an issue, and the court said it wasn't clear that the photograph he looked at was the same area. It was the same area. It was the bottom lot by Central Avenue. And that's where plaintiff came off the bus on Central Avenue and walked through the lot. It was the same lot, so there's no issue there. So he admitted in that lot, he piled up this into snowbanks. He admitted that.
As a general matter, not 2 days before the snow, not a week before the snow, but just as a matter of, here's what we do, correct?
Every time they do
Right,
it.
every time they do it, but
And
not, we
there were
did,
fi-
counsel, let me just
Sorry.
finish what I had to say, please, and I promise I'll let you speak. Not during this week, but just as a general matter, here's how we do it, right?
Every time.
Yes.
And they were there earlier that week.
Thank you, counsel. Matter of New York State Unified Court System. You may begin. Thank you.
Thank you very much. Good afternoon, everyone. Greg Laufer from Paul Weiss for the Appellant New York State Unified Court System. The Supreme Court's ruling upholding PERB's decision was wrong. It should be reversed. There are three main reasons why. The first is the standard of review. PERB and the Supreme Court held that arbitrary and capricious review should apply. That was incorrect. The correct standard is substantial evidence.
I'm baffled by that because I couldn't find anywhere in the record where your client disagreed with any of the facts found by the ALJ, all of which were affirmed by PERB. So if they don't disagree with any of the facts found, I don't understand how a sufficient evidence standard gets you anywhere, because there's no disagreement about the facts. So my question to you is, where in the papers do you show that you disagree substantively with any facts found by the ALJ, especially in light of the fact that your petition in its statement of facts relies on the statement of facts of the ALJ? So where do you differ from them?
Sure. So I think that there's a difference here between the facts underlying the ALJ's decision and the ALJ's sua sponte determination that the testing and vaccination policies were not inextricably bound up.
That's not really a factual finding. That seems to me that's a question of law. So I don't see where substantial evidence comes in, because having read the cases on this, which I was not an area of law I've dealt with a lot, but having now read a lot of cases on it, it seems to me that the inextricably intertwined issue is really a question of law and not of fact.
Sure. So, Your Honor, it can be in certain circumstances. We are not advancing the proposition that this is absolute or wouldn't, and certainly the position that you're describing is what the appellees have said. But there was no interpretation of a case here. There was no interpretation of a regulation. There was no interpretation.
So where do you allege specifically that the inextricably intertwined standard is somehow was inappropriate because of the substantial evidence standard? I don't see that anywhere.
It's a little bit, first of all, it is in our Article 78 petition. I can direct you to the actual page, but—
That's what I was asking for, but I guess you can't do it right now.
I don't have the exact page of the Article 78, but we did in fact contest that issue. It's never been waived, and there's never been a suggestion that it was waived.
There was
Can you
no—
at least-
Go ahead.
Can you at least paraphrase what the factual underpinning is different than a legal question, as my colleague mentioned, of inextricably intertwined?
Sure.
And I still don't get it. I listened, and I'm not getting what you're saying.
Absolutely, Justice Hagler, and we can take this very circumstance. There were testing and vaccination policies. Nobody disputes, and PERB agreed that that was not the subject of decisional bargaining. So the question about whether to put a piece of paper out there that says, you employees, you unions need to do X, Y, Z, that's all out there. How that was actually going to go into effect and what the impact of that was going to be on the employees, those two things are inextricably intertwined. It's a purely—
Still not giving facts. You're just stating that
Okay, well—
the standard was cited incorrectly by the ALJ, and it's inextricably intertwined, which may
I'll
be
be
the
more
case.
specific. The piece of paper that says this is the policy, it would be nothing more than a piece of paper if people didn't actually go out and go get tested and go get vaccinated and know how much time they were going to have off for that, how much they were going to get paid, what the consequences would be. the court simply wouldn't be able to function. That is a purely pragmatic, practical, tangible, factual issue.
It seems to me that you've moved on from substantial evidence to inextricably intertwined. And the other thing I don't understand about your argument is that it seems to me that there are several Court of Appeals decisions, most recently the City of Long Beach versus PERB from 2022, which distinguishes very clearly between a statement of policy and the procedures. And in that case, it's whether or not city has to negotiate over a procedure of terminating city employees under certain circumstances. And the court distinguishes very clearly between the fact that the city has the right to do that, but that the policies and procedures, the procedures for doing that are a matter of negotiation. Similarly, in the 2000 case of City of Watertown versus PERB, very similar. So if those two cases don't involve policies which are not inextricably intertwined with the procedures to carry out the policies, I don't see why this isn't.
May I answer?
Please.
Thank you, Your Honor. They're different, Your Honor, because for a couple of reasons. And I just want to emphasize in response to your questions, the standard of review here, we believe that we win for the reasons we stated in our brief under an arbitrary and capricious standard or under substantial evidence. But to answer your question more directly, as everybody I think here will recognize, including Your Honors, the UCS was operating in unprecedented times. There is no—
We're aware of that, counsel.
Yes, absolutely. No, but that is—
There are also emergency procedures with regard to negotiation. There's no problem with an agency putting into place emergency procedures and then continuing to negotiate.
Absolutely.
So that's not an answer at all.
Okay, well, I'll give you two answers, both in the form of Court of Appeals cases. One decided in, I believe, in 2006, and the other one decided in 2014. Both the Patrolmen's Benevolence Association decisions from the Court of Appeals, which clearly stated under those circumstances where you're dealing with a core public policy or a constitutional mandate that was, as we have here, or a statutory mandate, the obligation under the Taylor law to bargain, to impact bargain.
You're talking about City of New York versus PBA?
Yes.
And that Court of Appeals case says very clearly that the decision is limited to its facts.
Yes, and we're not saying that this decision has to be limited to any more than its facts either. And as you correctly pointed out, this is incredibly sui generis. There is no other case dealing with an emergency and urgency. And
I didn't say it was sui generis. You said that.
No, absolutely. I'm sorry. I said it, and that is our position. But if there are no other questions, I will rest until my rebuttal time. Thank you.
Good afternoon, Your Honors. May it please the Court, I'm Laura Delaney on behalf of the Respondent Public Employment Relations Board, and we are requesting that the Court uphold the lower court's dismissal of the petition here.
I just want to make sure you are not in any way, shape, or form saying that the PERB is saying PBRB, saying that the question of whether you had to vaccinate or test is subject to bargaining, right?
No, both the ALJ.
You all agree that
Yes,
that's
everybody's
not
in
subject to
agreement, yes.
bargaining.
No, that's a non-mandatory subject.
What you're arguing is that whether or not you get paid time off for it and what the penalty is if you don't do it was subject to bargaining.
Yes, and in fact, I think that our board in considering the—
And can I ask you one more question? You are not seeking reinstatement for people who— You're just seeking, if you took your own time off and you had to put in for sick time or vacation time, that you get paid for that.
Yes.
That's all that we're talking about here.
Yes,
I
the
want to
board
make it very clear. That's all we're talking about.
Yes.
Is those types of issues.
Yes, the board limited the relief that was afforded from the ALJ below, said that it's actually very, very restrictive. There were certain unions that were afforded.
Well, I mean, initially it wasn't.
No, you're right. Initially it wasn't, and our board's decision made it very restrictive. Only certain unions get certain relief. Some unions are not very happy about that, and we will be in the second department litigating those issues. And then the other unions weren't afforded any relief at all, and no employees are entitled to reinstatement.
How do you respond to the argument that UCS was faced with an emergency, and therefore not only did it want to implement this policy, it had this policy in place, it needed to implement it right away?
Yes, there's a workable framework here. 40 years.
Which one is?
Which is, so they had two options. One was established in the Wappingers case, there could have been an emergency exception here, which is exactly what was just discussed, where essentially you try and bargain with the union. There's no timetable where impasse needs to be declared. It could be a couple of days, could be longer than that. That depends on the parties and the nature of the emergency. It's very fact specific. And then the employer can unilaterally implement its policies, so as long as it commits to continue bargaining them to working out a final resolution. And this is something that's been long established under PERB's case laws. Invoking that is absolutely something that the public employer here had the right to do. The other thing that the public employer had the right to do, I would point the court to the New Rochelle case, which is cited by UCS. In that case, the parties actually, there was a budget emergency, and instead of going through the whole hearing process, they actually skipped over that and asked for a decision directly from PERB's board, and PERB did that. It's due to the emergent nature, or the emergent nature of that case. And then the other thing is City of Long Beach talks about actually using PERB to resolve fears that employers commonly have that they bring to us, like deadlock in negotiations, delays in implementing policies, because PERB itself actually has procedures like mandatory impasse arbitration, petitions for declaratory relief, where we can get people answers and decisions quickly. The employer here did not do any of that. It didn't even try.
Said it wasn't going to negotiate at all.
It wasn't going to negotiate.
Instead of just saying, let's negotiate for a day, see if we can come up with something. I'll declare an impasse. I'll do what I'm going to do because it is an emergency.
Yes.
And that's permitted under the Taylor law.
Yes, Judge.
Right.
And I would end by saying, because I see my time is almost up, I believe that our board in its decision was actually very cognizant of the novel issues that the coronavirus especially had an impact on public employers and the court system. And so, we understood that there were novel challenges here that public employers were grappling with. But this was actually not a novel circumstance in terms of a legal framework for how PERB should be assessing and resolving this specific labor dispute, because employers have been coming to PERB for over 40 years after exercising their managerial prerogative in a decision which they are lawfully able to do, but then arguing that all of the procedures and consequences of that decision going forward should also be removed from mandatory collective bargaining. This is not a new argument.
Should we give deference to the board with respect to this analysis?
Yes.
Why?
Because there's a significant amount of case law saying that this is an area in terms of the Taylor law, how the board interprets the Taylor law, the public policies advanced by the Taylor law, like the policy that all public employees in this state have the right of collective bargaining to engage in collective negotiations. The Court of Appeals has called this a substantial right. Exemptions and exceptions are not to be carved out of this easily. So this is something that PERB takes into mind and in consideration with its decisions that is entitled to deference. Thank you.
Counsel.
May it please the court, good afternoon. Seth Greenberg on behalf of the responding court unions. I learned many years ago to speak only if I have something to say, not just to say something. So unless your honors have any questions,
I do have a question.
we're going to rely on the, yes.
How do you respond to their argument that the remedy that PERB imposed of, in essence, making the employees whole was unnecessary, and that the proper remedy would have been to send you back to bargaining, negotiate the terms and
Well, Your Honor, that is precisely what the unions had requested, right? So the whole part is put them in a situation they would have been at the bargaining table. Remember, as counsel for PERB indicated, this is not rewarding non-compliance with the policy because there is no reinstatement. We're talking about employees who complied with the policy that may have expended time or money to get tested or vaccinated. There are questions about the process put in for medical or religious accommodations and appeals. There's issues about time and leave.
Although we've addressed the religious accommodation issue,
And that's
I
not
don't know
before
what issue on that is ringing a nasty bell with me, because we've addressed that issue. What do you think the unions are raising about religious accommodation that other people are not? that haven't,
the-
that other
the-
people? What do you mean?
Really, the only thing that the unions have focused on is a process to be able to put in a request
Didn't,
for
didn't
its
anybody who had, every city employee, every state employee, there was a process.
It was a process that was unilaterally implemented, and that's exactly.
Oh, are you going to challenge, is that one of the things you're saying, that you should have bargained, that you had the right to bargain?
Well, there's a process in terms of being able to put
I'm
in.
asking you about the process of the religious accommodation, because I didn't understand that from PERB. You're saying that that had to be bargained?
We're saying that all of the effects of the policy, including the procedures of who you put in, where you apply to for medical, for time and leave, that has to be bargained. But I want to make clear.
Including, because we've dealt with, I want to make it clear, I want to ask what you are seeking. You're saying that you want to be made whole from the fact that you didn't, that people were denied religious exemptions for the vaccine?
No, it's just that there was never a process in place for anybody to put in accommodations in the past. And so therefore,
No, there was an accommodation. We've dealt with it many times on this.
not in the court system.
Okay.
Thank you.
Thank you.
Thank you.
I have to ask you about that, because it's my understanding that any worker who didn't want to, could put in, anyone who worked for the city of New York, anyone who worked for the state of New York, could seek a religious accommodation. Is that not correct?
It is correct.
All right.
Let's forget the standard of review for a second for the reasons I said earlier. It is undisputed, and the factual record is brimming with evidence, unrebutted testimony from senior executives at the UCS that impact bargaining, that there was no way to implement these policies and do impact bargaining.
Why couldn't you negotiate for one day, call an impasse, and then implement?
Okay.
And follow exactly what the Taylor law requires you to do, and then continue to negotiate as you're implementing.
There were, in fact, discussions, but a premise of your question and a premise of what my friend on the other side just said a few moments ago is that you could implement the policy, meaning put out the piece of paper, and then spend, and I think the word a few moments ago that we heard was months, which is what we also said in our brief. Yes, it would have taken months and months. Nobody disputes
No,
that.
declare an impasse. That's the whole process is very clear. You negotiate for one day and declare an impasse. And then you put your policy, and then you do your procedures while you make a good faith attempt to negotiate.
There were good faith attempts to have, there were telephone calls and meetings on these very issues. It was very clear that the unions were not going to accept.
So then you declare an impasse. That's what the law requires you to do. It's
I could be mistaken, Your Honor. I do not believe that there's an argument that's been raised by PERB or the union suggesting that if we had just met for one day in good faith and then declared an impasse, that we wouldn't all be sitting here. I'm very skeptical that that would be the result.
I just want to go back, counsel, because I'm having a hard time processing. You know, I just don't understand how this is inextricably interwoven. I mean, there is a policy. No one is, challenging, UCS's right to establish a policy, right, when it comes to testing, vaccination. So, the quote-unquote procedures, that doesn't affect the policy, but you seem to be like conflating the two. To me, it's like separate.
Thank you, Your Honor. I appreciate the distinction. That's actually a distinction that was never raised by us during the ALJ proceedings, the distinction between the decision to implement the policies and procedures. We frankly believe that that's a manufactured construct here. It doesn't apply. There are decisions to implement policies, and then there are the impacts on the terms and conditions with respect to the policy. There are no procedures here to speak of. And to answer your question directly on the inextricably intertwined, if you, and again, I think I said this a few moments ago, if the UCS had simply posted something on a bulletin board saying, thou shalt get vaccinated and thou shalt test, what would have happened in actuality? How would employees know how long they could take off? How would they know what would happen?
That's why you had to have procedures, and that's what had to be negotiated.
But that would have taken months and months, as
not
nobody
necessarily.
disputes.
First of all, you had no right to impose it as an emergency and then negotiate about it, or you had a right to negotiate about it and declare an impasse. You didn't do either of those.
Those seem like two sides of this, if I may address the
They're two
question.
different
Those seem like two sides of the same coin. That is not an argument that I believe that the other side has ever raised. And again, I do not believe that we would all not be here right now if it were really the case that, I mean, and my friends on the other side are right here. If we had just said, sorry, it's 5 o'clock, we're done, we've been talking all day, and we're declaring an impasse under Wappinger and we're good to go, I cannot imagine that we would not be here. I do not believe that's the case, and it's never been an issue that's been asserted. Thank you.
Thank you very much. Thank you. Isaac versus Briarwood Insurance Services. You may proceed. Thank you.
Good afternoon, Your Honors. May it please the Court, Christopher Bradley for Atlantic Casualty Insurance Company. It's our position that the complaint does not state a cause of action for which relief could have been granted and should have been dismissed. This complaint seeks to recover damages for plaintiff's own property. It's not a third-party claim, so it's a first-party claim. All the damages allegedly result to a botched kitchen installation in the plaintiff's cooperative. While not actually...
So does the plaintiff have insurance with your client?
No, Your Honor.
And so she is, in essence, trying to recover for something someone else did?
Correct, Your Honor.
And has she gone after that other someone?
Not to our knowledge. I have no idea.
So she is going first against the insurance company to recover for whatever that other party did?
That's one way we could look at the complaint, I believe, and the Court of Appeals in Lang is crystal clear that you can't maintain a direct action absent an unsatisfied judgment against the tortfeasor insured.
Do we have one here?
We do not. It's neither alleged or pled in the complaint.
Okay.
Now, there was a certificate, but that was only issued for informational purposes, and that certainly didn't confer any rights to the certificate holder, the plaintiff.
That's correct, Your Honor. The law is clear. A certificate of insurance is for informational purposes, confers no rights, and does not create any privity between the plaintiff and my client.
Any other questions? Okay.
Unless the court has any questions, I'll rest.
Good afternoon, may it please the court. Erica Itzak from the Itzak Law Group for the plaintiff respondent in this matter.
Are you the plaintiff?
I am.
Okay, I just wanted to make sure.
Welcome.
Thank you, Your Honor. One of the significant facts, and while yes, a certificate is issued for informational purposes only, it cannot be issued if it is not based on an actual policy in existence. And it's important to note that on the certificate, on the accord binder, which, or the certificate of insurance.
Who's the main insured in that certificate of insurance?
Actually, I am listed as an additional insured.
Right.
As was my cooperative building as was the cooperative building. The insurance policy belonged to the contractor who did work in my cooperative apartment. And
So you retain a contractor to do work in your apartment, and they were required to purchase insurance, and that insurance was to name you and the co-op as additional insureds.
Actually, Your Honor, the only requirement was that it named the co-op. A requirement that I had with entering into the agreement with the contractor was that I be named and listed as both a certificate holder and an additional insured for the exact purpose of a contract.
What rights did you gain by being listed as an additional insured? Did you have the right under that policy, if it was issued, to go directly against the insurance company?
Yes.
Or did you have the right to have the insurance company defend and indemnify you in the event that you were sued by someone else for any negligence that anyone had committed in your report?
Both, which is the difference between being listed as only an additional insured versus also being listed as a certificate holder. And this was all confirmed with defendant Atlantic Casualty's agent, Briarwood, at the time when the agent provided the certificate of insurance and accord binder. And I should also notice that, and the purpose for doing this is exactly what happened in this case, that the contractor is no longer in business, as is what happens with probably 99.9% of contractors that perform subpar work and would end up the subject of litigation.
Did you sue the contractor?
No, to sue someone that's no longer operating would be not only a waste of judicial resources, but a waste of everyone's time.
Did you ever consider trying to get a judgment and then going after the insurance company to enforce the judgment?
The issue with that becomes when you're dealing with a contractor no longer in business, you then enter into...
And you get an easy judgment, right?
Maybe yes, maybe no, because then you have service issues. If the company's properly dissolved, you can no longer... the company's been...
Have you looked to
no
see
longer
if the
operating,
contractor...
You can't serve through the Secretary of
Have
State.
you looked to see if the contractor was dissolved?
As of the time when I brought this litigation, I was informed the contractor was no longer in business.
How did you learn this? Did you get a document or did you just hear it by word of mouth?
I believe I attempted to contact the contractor, and that's when I was told they were no longer in business.
Generally, what you do is you look at the Department of State to see if they filed a dissolution.
I understand, Your Honor, and even if they hadn't filed a certificate of dissolution, if service is made through the Secretary of State and I have actual knowledge the entity is no longer in business, then all somebody has to do is come back and question service. So then I'm no different from where I am now. And again, being listed both as the certificate holder and the additional insured here, I believe is, and this is the trial court's finding, that is what does create a valid cause of action against Atlantic Casualty here. And I should also note that Atlantic Casualty didn't even appear for oral argument on their motion to dismiss. Thank you all very much.
A few points. The record at page 39 contains a copy of the Certificate of Liability Insurance. The respondent is not the certificate holder on the Certificate of Insurance in this record. The co-op is. And regardless, it would not have created any rights or privity with the insurance.
And it says that right on the certificate, right? This certificate creates no rights for the additional.
Absolutely, and it says even at the top, you have to look at the policy. And for purposes of completeness, even on a 3211A7 motion, we've enclosed a certified copy of the policy. The policy is a general liability policy. It doesn't provide first-party property insurance for anyone, a named insured, an additional insured, or anyone else for that matter. The insured didn't purchase that coverage. The respondent is not an insured, and regardless, the policy, that kind of coverage was not even purchased. So we contend whether it's a first-party claim against the insurer, the policy doesn't provide the coverage, and a third-party claim, the Court of Appeals in Lang has spoken clearly. And I rest on the argument, Your Honor.
Thank you.
Thank you.
Matter of Panstar Realty. You may begin. Thank you.
Good afternoon. Michael Jagiani for Respondent Appellant, New York Teachers Housing Corporation. This appeal stems from an access order granted under RPAPL 881 to petitioner in the underlying proceeding pending before Judge Perez in Bronx County Supreme Court, so as to allow petitioner to complete a ground-up construction project. At the onset, it should be noted that this statute, after a very long time, was amended in December of 2025. Pursuant to the amendment, it is respectfully submitted under the amendment and under the original law that the lower court committed reversible error in 4 ways. One, in granting an order that did not allow for adequate license fees to respondent, and granting an order where...
Counsel, can I just ask you regarding that license fee? What evidence was put into the record with regard to the amount of the license fee?
The evidence that was put onto the record had to do with a loss of use of the property and diminution of lower property values. An affidavit was provided from the co-op board president, Vanessa Kim, which established the tremendous burden the cooperative and their hundreds of residents were forced to undergo as a result of this construction. That included a controlled access zone being placed 20 feet over onto the respondent's property, the subsurface damage of a water line that now needs to be repaired, continual debris raining down on the respondents and their tenants, harassing conduct by the developers.
Was it limited to the loss of the 10 parking spots?
Well, Your Honor,
sorry, thank you. Gotcha.
Your Honor, there were 11 parking spots that were affected. In determining the order, the license order, what had happened was the court multiplied 11 by the discounted parking rate that was made available to the shareholders. That number came out to about $1,375 a month. The court basically...
I mean, it was the actual amount that the co-op received from those renters, right?
That's correct, Your Honor. In doing so, they completely disregarded all the other evidence that was before the court. As the statute is amended now...
What evidence was before the court? I'm trying to figure out, I understand that there was a certain fee and they didn't get, we understand the $1,375. Where do you get the remainder? How do you get more than $1,375? Where's there evidence in the record that would show how we can compute that?
Well, the calculation for loss of use also includes how the residents would be impacted by the adjoining construction. So the case law talks about loss of enjoyment, right? So
what else did you lose besides those 11 parking spots?
We lost, there's debris falling on the material, on the tenants themselves.
The debris falling on the tenant? There was no safety netting or something that would prevent that?
No, there was letters exchanged from my office to opposing counsel on several occasions where there's wet concrete spalling over onto the residents in their vehicles. There's obviously construction dust and debris.
Counsel, don't you have a claim for damages for that? We're talking about a month-to-month license, right? And you're saying we were damaged because there were some tenants and they'll testify, and you have a claim for that, right?
Yes, Your Honor.
So let's assume that that's covered by that claim. The question is, what evidence did you put in about additional amounts that had to be on a month-to-month basis to do the license?
Well, Your Honor, the evidence that I referenced was an affidavit by the cooperative board president, and that goes to loss of use.
Agreed, but that's damages based on the grant of the license. Again, we're talking about what are you losing month to month, dollar signs, because of the license? Well, and the 11 parking spots we all agree about, right? And what else? What did you put in that said that there was a tangible month-to-month loss?
Well, if I may address that by citing a case, Your Honor. The first department in the matter entitled 268 West 12th Owners Corp. Versus Const ordered a $5,000 a month license where a garden was impacted by neighboring construction, and sunlight was basically depriving this garden to grow. That's on an individual unit. Here, Your Honor, we have hundreds of tenants being affected by construction. When you ask what are they being affected by, obviously debris. They have this continuing access on their property. Under standard license...
Are you saying they can't access their property?
Yeah, in the upper level lot, they have difficult turning out of the lot. That's something that's been in the affidavit. They have significant debris falling.
When did it just affect the 10 parking spots? How is it I'm sorry.
No, go ahead, please.
So you're telling me that 11 people that couldn't use their spots would be affected? Was it wider than those 11 spots? That's the part I'm not understanding.
Well, Your Honor, under the new amendment, diminution of value is considered. Obviously, a building that has a 20-foot controlled access zone has lower value, right? It's harder to rent the apartments. It's harder to sell the apartments. At issue also, Your Honor, if I may, another lights on, if you give me a moment, we had requested a hearing to address these issues. Given the fact that these issues were all contested under CPLR 409, this matter was not ripe for summary determination. The court refused to hold a hearing. The precedent in this department shows that oftentimes, most of the time, in projects of this scope and scale, hearings are held. We were not giving a hearing.
What case? Because I haven't found one. What case did they hold a hearing on license fees? DDG Warren says the opposite. It's within discretion of the court.
In 152, I think 62 LLC, there was a hearing for a license fee. The issue again is that we were deprived of the ability
That's
to put
an
in
appellate
evidence.
division case?
Yes.
Thank you.
Thank you.
Thank you.
Good afternoon, Your Honors. Raymond Mellon from Zetlin de Chiara for Respondent Panstar Realty, LLC. We believe, my client believes, that the decision of the court below was proper. We set forth evidence required under RPAPL 881, establishing our need for a license. A license is very
Why
defined.
did you need a license?
I'm sorry?
Why did you need a license when there was no longer a stop work order and you could continue to build your project?
Well, you can tell by some of the plans here, Your Honor, we're building up to the property line. And directly over the property line are the 11 parking spots in question. Under the code, the building code, when you go over 100 feet, you're required to have a protection zone of 20 feet. So we have to put up a fence to protect the people. And in addition to that, we need to do some work in that area. Now, the work is limited because, frankly, right now, the building is up, all 7 stories, and we were able to build, once the stop work order was lifted, I should say, we were able to build the walls, the CMU walls, and put the brick on the outside facade from the inside. However, imagine the full wall, the size of this panel. 1/3 is already done because there was openings, and another 1/3 is done. The rear and the front areas are closed, with the bricks done. But in the middle, there's a sheer wall. We still need, ultimately, to use our scaffolding, which is going to be on the needle beams that you've seen in the...
So that's all you need.
At this point, yeah.
That's all you need is the needle beam.
Right,
You don't need the stop order, the work order was lifted, and
Yes.
you got permission to do the needle beams. And that's all you need. This license is quite a bit broader than that.
It is, Your Honor, and if I can explain a few things. One, the stop work order was lifted, and one important point is that originally we were directed to do the minor repairs, leaving aside the drainage issue, which, by the way, no professional engineer has established that my client has, despite extensive testing on their part, that we damaged their drainage system. We did damage this curb retaining wall, which is no longer a retaining wall because now you have a 100-foot building.
But again, that's a separate thing. Those are damages for, we're talking about this license today.
Correct.
This license today, the only thing you need a license for is the needle beams.
Yes, and the reason why I'm trying to just explain this, Your Honor, because I think I can help a little bit here, is that the DOB originally said, last thing you have to do before we're going to lift the stop work order is you got to fix the parking lot and that curb, which we've always been willing to do. Ultimately, when we got into a dispute with the co-op and we couldn't do it, we explained to the DOB that they started a separate lawsuit seeking damages and that this is something that will be resolved there. We have no problem if this court determines that the issue of Justice Perez told us to repair, because when we started the action, the stop work order was still in place, requiring us to do that. Subsequently, it was lifted. But we have no problem if you determine that the issue about the repairs to the parking lot and the curb wall are something that should be done in the plenary action. We're fine with that, Your Honor.
How do you respond to the appellant's argument that the needle beam plan exceeded the scope of the petition because it wasn't even set forth in the petition? How do you respond to their argument?
Well, Your Honor, it's what I say in the papers, that it's no good deed goes unpunished. They complained about the problem that we were going to put heavy scaffolding on the area that said it was damaged. So we went back, scratched our heads, and said, let's have the engineers come up with something different. They came up and said, hey, this is going to be more expensive, more involved, but you can put needle beams, which the DOB has completely approved and issued a permit for, and you could build on there so you won't be putting any weight on the bottom. Now that Justice Perez gave the co-op the right to put in a reply affidavit and put in any evidence they wanted to if I raised something on my reply, which I did. I totally admit I did. I put this in because we wanted to resolve the issue. And they had every ability to put in some evidence. And in essence, all they're doing is saying the DOB is wrong. Even though they're the expert construction agency in the city of New York, we're right, they're wrong. So Judge, please substitute your decision, your opinion for the DOB. So.
Thank you.
Thank you, Your Honor.
Just a few points on rebuttal.
Counsel, may I ask you, you sought engineers' fees and legal fees, right?
Correct, Your Honor.
And it was unclear to me what happened with that. What happened to them? What happened to the hearing on that?
We never received a fee award in this case, Your Honor.
So you're seeking a fee award on attorneys' fees and engineers' fees?
That's correct.
Right? Okay. And I guess there was a catch-all and anything else below that said and anything else is denied, but that wasn't specifically addressed, right?
That's correct, Your Honor.
Okay.
And just a couple of points in rebuttal. First off, there is a stay order of the appeal that was issued by this court on September 4th of 2025. Just so the record's clear, construction has continued unabated during this period. The building has gone up as admitted by counsel today. That's something that this court should consider. Secondly, this issue about the stop work order. Just so the court's clear, my client agreed to enter into a pre-construction agreement with Panstar to allow them to complete their SOE work and their first floor foundation. They had access for an entire year. When this flooding issue arose, which is substantiated by expert testimony, and I take issue with the comments by my adversary, they refused to pay for our engineer. It's at that point that Panstar went ahead and filed its petition. At the time they filed the petition, there was still a DOB stop work order in effect. For that reason alone—
Basically, though, you said, we want to do the work. We want to do it with our engineers, our people, our thing. We don't want them to do it at all. That's what we want, right?
Well, Your Honor—
Is that not what you said? We want to do the work. We don't want you to do the work.
In essence, it is, but with the qualification—
So, I mean, that's a problem,
Well,
right? Because who knows if you're going to hire somebody that's 8 times more expensive than they need to pay.
Well, the issue is in the direct area where the controlled access zone is, where these protections are going up, there's a displaced drainage line. Despite counsel's contentions to the contrary, we had a test pit dug with camera inserted into the line, which showed a displaced line. That's corroborated based on reasonable engineering certainty by our expert.
But we
and that
get-
is what.
we
Sorry.
have experts who say completely different things in this case, as in most cases. So yes, of course you have an expert who's going to say what you would like to have done, and your adversary has another expert plus the DOB who's saying something different, right?
But for the fact that our expert's opinion was based on an actual physical examination with the camera. There's unqualified damage in this area, Your Honor, and that's part of the problem.
Right, you've sued for that. You have a plenary suit for that, right?
Right, we have a plenary suit for
We're
that.
just talking about the license here.
Of course, Your Honor. So again, just to reiterate, at no point was there bad faith on my client's part. We allowed access for a year. We continued to cooperate. The breakdown happened when counsel refused to entertain an additional payment for an engineer related to this water damage that was ongoing.
Can I talk about the bond? You also are arguing that the $250,000 bond was insufficient. Why is it insufficient?
Because bonding in these actions has been held to be, it needs to be correlated to the license fee that's issued. The precedent in this case shows that in a similar circumstance, on a $1 million bond was awarded on a $1,200 license fee. I believe the other case was matter of New Garden that was cited. On a $3,500 license fee, there was a $2 million bond. In this
Now that the only safety requirement is the needle beams, why would you need more than $250,000?
because the bond addresses potential damage going forward related to the construction. We already have put forth.
Is there an expert or some other evidence in the record that would show that you would need more than $250,000 as a bond?
Of course, there's material raining down on the tenants and their vehicles.
Do you have an engineer or someone that backing up that there's a necessity for more than $250,000?
We're relying on the precedent, Your Honor. I mean, the precedent
There's no affidavit or from an expert to say that $250,000 is insufficient?
Well, an expert would have to opine on what the potential damages are. Obviously, the potential
That's what
damages
I'm
are
asking
limited.
you. Did someone go through that process and introduce into evidence something more than just your request for more than $250,000?
It's submitted that such an opinion would be speculative, right? How would they know? If I may continue, or we have a couple more minutes. Okay, so just to continue, regarding the license order itself, it allowed permanent improvement on respondent's property. That was flatly disallowed under the prior precedent. It's been amended now, but under no version of the law are permanent improvements allowed to be made on licensors' properties. Basically, what happened here is the attorney was arguing on one side that we'll build a non-structural ornamental wall for you. On the other hand, they're arguing that there's no need to build anything because this lot's going to be supported by this new building. Under either version of the law, we would submit that that's improper and must be reversed on those grounds alone. And I rest on my papers. Thank you.
People v. Porter. Counsel, you may begin. Thank you.
Good afternoon, Your Honors. Victorian Wu, Office of the Appellate Defender for Sharon Porter. The police did not have reasonable suspicion to stop the car in this case. The police only had a vague description of a black man in a white T-shirt.
Before we get to that, can we address the appeal issue? You know, why isn't this valid? Can we get to that?
Yes, Your Honor. So the appeal waiver in this case is invalid because of the combination of the misstatements that the trial court made in trying to explain the scope of the appeal waiver. So the prosecution failed to advise the court at the outset that an appeal waiver was part of the plea, and when almost at the end of the colloquy, the prosecutor belatedly told the court that there was a waiver, apologized to the judge for not advising the court in advance. The court then tried to pivot to that subject. And in the course of trying to explain the appeal waiver to Mr. Porter, the court made two misstatements. So first, the court told Mr. Porter that he would, quote, waive his right to appeal most claims of error except for, end quote, and the court then named 4 specific issues. So that statement was incorrect because the 4 specific issues that the court named are not the only ones that survive an appeal waiver. And importantly, this departed from the model colloquy, which says succinctly and accurately that 4 issues are only among those that are that survive the waiver. So there are other issues that survive. So that was the first misstatement that the court made. The second misstatement was when the court said that, quote, unless waived, the defendant has a right to waive a criminal conviction and be represented by a lawyer in that appeal. So that statement was also inaccurate because it improperly suggested that the right to counsel was subject to the waiver. And this also departed from the model colloquy, which makes no such suggestion. And while there was a written waiver form that was signed in this case, they were not able to cure the court's misstatements. That is in part because the written waiver didn't clarify that any other issues beyond the 4 that the court had named would survive the appeal waiver. And finally, the written waiver didn't say anything about the right to counsel. So given the totality of the circumstances, the appeal waiver was not knowing, intelligent, and voluntary, and does not bar this court from reaching the merits of the suppression claim.
But if we did find, just hypothetical, that it was waived, then certainly the suppression arguments are foreclosed.
That would be correct, but my position is that on this record, the appeal waiver was not knowing, intelligent, and voluntary because the court mischaracterized the scope of the waiver in trying to explain that to the defendant. So turning back to the suppression issue, the police had only a very vague description of a black man in a white t-shirt. That description was given by an anonymous caller. The police did not know the identity of.
Wasn't it also significant that he was the only person standing in front of the building which had been described? I mean, they were given a specific address, and he was standing in front of that building, and he was the only person dressed like that standing anywhere near that building. Isn't that significant?
The problem with that is that the officer conceded on cross-examination that when he got to the scene, he didn't check to look around the area to see if anyone else happened to match the description. And again, this is just a very vague description, a black man in a white t-shirt. The video, in fact, shows that within the minute of the police arriving on the scene, there was another black man wearing a white t-shirt at the same corner. So given the generic nature of the description, the officer's failure to check whether anyone else on the scene met that description, there was simply not reasonable suspicion to stop Mr. Porter in that case. And in fact, the prosecution conceded at the suppression hearing below that the combination of the 911 call and Mr. Porter matching that description was not sufficient to create reasonable suspicion.
What about him entering a vehicle as the vehicle is approaching, walking quickly towards that vehicle and entering the vehicle, and the vehicle driving away while the door to the passenger side is still open?
So that conduct was innocuous for a number of reasons. One is that Mr. Porter could not control.
Innocuous, did you say?
Yeah,
Getting
well-
into a car as it's speeding away and the car door isn't even closed, you're saying is innocuous behavior?
So a couple of things. The car was actually moving quite slowly, as the video showed. I think respondent concedes in his brief that the car was moving slowly. The other thing is that Mr. Porter did not control the movement of the car. He is akin to someone entering an Uber or Lyft or any other for-hire driver. The driver may have been slightly less than careful than we might want, but that does not reflect on Mr. Porter at all. And importantly, there was nothing.
What about when that vehicle is stopped and the occupants are ordered to show their hands, your client not complying?
Right, so that is not relevant to the analysis whether the stop was legal in the first instance because all that took place after the stop happened. Looking at the information that was available to the police at the time of the stop, all that they saw was Mr. Porter approaching a car, walking into it. Yes, the car was moving slowly with the car door open for 1 second, but again, that is not reflective of Mr. Porter, and they didn't see Mr. Porter do anything suspicious. He was standing on the corner and got into a car that describes any number of New Yorkers who similarly stand on the corner.
Counsel, isn't it uncontroverted that I don't believe that the defendant was walking quickly towards that car, away from the building where the anonymous caller or the 911 call came from?
So two things. Factually, I think that's incorrect because the video shows that he was walking at a normal pace. I think respondent does not.
Didn't the officer testify that he's walking quickly?
I don't recall, but even if that were true, I think the Court of Appeals held in People v. Moore, and this court has repeatedly held in, for example, People v. Thorne, that walking away quickly from the police is not enough to create reasonable suspicion.
But all the factors together, there was within 2 minutes, the individual was within the proximity of where the call was. The identity of the person is a black man in a white T-shirt. And then the third thing, together, I'm talking about totality of circumstance, and then going fast, going into a car, moving while the car was not closed, and they were going away from the scene of the incident. Isn't that the totality of circumstance? Doesn't that at least give suspicion?
No, Your Honor, it doesn't
Wouldn't
give
be
rise to
suspicious?
reasonable. It doesn't give rise to reasonable suspicion. It may give rise to founded suspicion, but founded suspicion is not enough to justify the seizure of a car.
Thank you, counsel.
Sarah Lubin for the People. I'll begin by addressing the appeal waiver. In this case, defendant did knowingly and voluntarily waive his right to appeal. As the court is aware, whether or not an individual voluntarily and knowingly waives their right to appeal is a totality of the circumstances analysis. In this case, defendant did have the benefit of a thorough colloquy from the court, as well as the assistance of counsel and a written waiver. And it's notable too that
And did the court actually say to the defendant, if you need more time to review this waiver, I'll give you the time you need? And defendant said specifically, no, I understand it, I get it, I don't need more time.
yes, and he was asked if
So there's no doubt that he thought he understood what he was waiving.
yes, and I'll also just highlight that this was a plea that there had been significant back and forth. The previous day, defendant had taken the evening to discuss the plea with counsel, came back the next morning, and counsel seemed to be well aware that it wasn't a surprise that there was a appeal waiver in this case. It wasn't a situation.
Let me ask you two more things about the appeal waiver. Did the court ever say to him, you don't get a lawyer on appeal?
No.
In fact, he said, you do get a lawyer on appeal, right?
That is correct. And the court's exact statement was, quote, unless waived, the defendant has a right to waive a criminal conviction and be represented by a lawyer in that appeal and have a lawyer appointed if he cannot afford one. And while there does seem to be perhaps a stenographic error or maybe a misstatement by Justice Farber's part when he repeats the word waive, it seems that was probably meant to be the right to appeal a criminal conviction and be represented.
Otherwise, the sentence wouldn't make sense. Right?
Exactly, but it still seems clear.
Oh, he never says to the defendant, counsel's arguing that the waiver is bad because he tells the defendant he doesn't have a right to a lawyer on appeal. But that is not what that says, correct?
Exactly. It's in fact the opposite, that a defendant does have a right to an attorney on appeal should one of those claims that do survive the appeal waiver be relevant to defendant. I'll also briefly just address defendant's other claim regarding the appeal waiver.
Not listing every single right that that is not waived on appeal.
Yes, exactly. The court appears to be, and there is a model colloquy, but it's not the only colloquy, and the Court of Appeals has been clear that there's no exact colloquy that needs to take place. But what Justice Farber appears to be doing is just listing for defendant for claims that most commonly would survive an appeal waiver. Of course, there are all sorts of crazy things that happen in the course of criminal prosecution.
What does the written waiver say? The written waiver is a little broader, right?
The written waiver lists the same
among others, right?
Among others, but does list the same claims. Right. I'll turn briefly to reasonable suspicion if there are no more questions about the appeal waiver. In this case, officers had reasonable suspicion to stop the car the defendant was seen getting into.
Could you explain why you disagree with your colleague about that?
Yes. So first, the 911 call in this case, there is reason to believe that this was a known caller, that this is a caller that officers were able to go back, speak with at the precinct, that this was not an individual who was hoping to remain anonymous, which is the guiding principle behind cases like Florida v.
Isn't it true that the officer did not know at the time that it was a person that was known, and to him it was an anonymous caller?
So the question during, I believe it's cross-examination, is whether the 911 caller was asked for their information when the 911 caller placed this call. And the officer responds exactly, I believe they did, but I can't be certain, I don't know. So there is some equivocalness. And then Justice Mandelbaum goes back and asks if he knew whether or not the caller was the security guard, which he says no to. However, obviously, the caller being a anonymous caller who refuses to give any identifying information versus identifying their job as an individual that might work at this building are two separate things. But it's our position that regardless of whether or not the 911 caller was anonymous, there was still reasonable suspicion in this case. Officers respond within approximately 2 minutes. They see defendant who, and the video has been provided to the court to make their own determination, but who you can see speed up towards the corner as this car continues to roll towards the corner. And then as officers come into view who have their lights on, defendant can be seen in my viewing at least, speeding up to get into the vehicle, which then attempts to pull away, but at that point, officers are immediately behind the vehicle. All of this, when taken in the totality of the circumstances, which is the analysis here, of course, gave officers reasonable suspicion to stop the car the defendant was a passenger in. And just briefly, just to the point about Uber or Lyft, that's really—
30 seconds.
I apologize. That's really not a appropriate analogy in this case. Defendant clearly in this case is getting into this car without any sort of conversation or confirmation from whoever may be driving. It's a very quick sort of flight, which is what the trial court found. Thank you.
Thank you.
Just a few points with respect to each of the appeal waiver and the merits of the suppression analysis. The appeal waiver is invalid because the court made a misstatement when it described the scope of the waiver and suggesting that the 4 claims that it identified were the only ones that would survive the appeal waiver. And Judge Scarpola, actually the written waiver form—
I don't understand what you're saying. How did they have, because they listed this 4, is there anything there that says, and there are no other claims that you can raise?
So I think the use of the phrase "except for" before listing the 4 claims indicates that the 4 claims were the only ones that would survive. And
So
importantly—
that's your, but if that's your interpretation of what, but when the defendant said, you know, I went over the written waiver, which is a little bit different, with my lawyer, I don't need you to explain anything else. I totally understand what I am doing here. Why isn't that enough? He's gone over the written waiver with his lawyer. The written waiver, even if the language is imprecise, says exactly what you wanted to say. And I'm sorry, I disagree with you that he suggested that the defendant didn't have a right to a lawyer on appeal. To me, it seems clear he said you do have one. So assuming that we disagree about that piece, I still don't understand why you think this waiver is not bad, particularly because the judge said to him, if you have any questions or there anything you want me to do, let me give you some time. Go to your lawyer. He made sure that the guy understood what he was doing.
Well, Your Honor, I think in short, I think the 2 statements I've highlighted in my briefs
If you could
are
pick out
misstatements.
things, of course, I speak imprecisely, so do you. But the totality of the circumstances here, I don't see how this could be a bad waiver. That's my issue.
So I guess I would have to disagree because I think that
I
judges
guess,
are
right?
obligated to
That's
make
right.
accurate—
And that's your job.
Judges are obligated to make an accurate statement about what an appeal waiver is. It's not that difficult. You can use the model colloquy, which this court has encouraged and the Court of Appeals has encouraged. And by deviating from the model colloquy, in this case, I think the judge made 2 incorrect statements of law that render the appeal waiver not valid and therefore unenforceable.
Thank you. All right. Brenis v. the City of New York.
Good afternoon, Your Honors. Waleed Rahman from Harris, Keenan, and Goldfarb for the appellant. This appeal presents a narrow but decisive error. The liability here turned on the well-established exception to prior written notice, whether the city's own work affirmatively created the dangerous condition that caused—
Do we have proof of that in the record?
Well, we have an expert who opined and concluded, based off all the evidence that he had, including an on-site inspection, photographs, all of that.
The on-site inspection occurred when? 3.5 years after the incident?
That is correct, Your Honor, but timing goes to causation, and there's
I'm glad you said timing, because what I want to know is, how did you establish that the city's work immediately resulted in the defective condition?
Well, the burden here shifted to the plaintiff to prove that. And our expert opined that the work that was done was defective when it was done.
He opined that the work that was done was, they use inferior material.
Correct. And
so how does that translate into they created a dangerous condition?
Well, Your Honor, it wasn't just that it was inferior material. He concluded in his report that they violated statutes, and including the wearing courses slope and the asphalt that was used, they violated multiple standards that he
In
cited.
his report, did he say that all he's reading from it, that it caused the roadway to become uneven and depressed? Didn't say right when it was done that was the problem. Said nothing like that. And nor could he, right? Because he looks at this 3.5 years later.
Exactly, Your Honor.
So without proof that the statute that requires and the case law requires that it has to immediately create the defect. And you have someone who said at some point, this caused the roadway to become, didn't say immediately, nothing like that in the report. So let's assume that that's not going to cover your burden. What else do you have?
Well, just very quickly on that point, he didn't use the word immediate.
He
that the
didn't
case
even
law
use
requires.
it close.
But he did say it was caused. And
That could be a week, a month, 6 years, whatever. So I'm saying, let's assume that doesn't meet your burden. What else have you put in?
well, to the extent that there were inferences here as to when it was made.
No, I'm not going to make any inference. If you're experts, you hire him to say something. If he doesn't say it, none of us are going to infer anything. Again, assuming that your expert doesn't say that immediately caused that depression, what else did you put in?
I respectfully submitted a case today, and I gave copies to my adversary and to your honors, Martin v. City of New York by this court in 2020. In there,
Was that case available to you when you argued your appeal, when you wrote?
it was available, but it wasn't in our brief, and we respectfully submitted today. It was this court's ruling in 2020 where a roadway defect was worked on 1 month before the accident. There was no expert there, and just testimony that the work was done. And this court found where there's no proof that the condition developed over time, which is the same case here. There's no proof that the condition developed over time from the city, nothing to rebut the expert. Then there was an issue of fact, and that's analogous here where there is an issue of fact as to when it was developed, that condition. So we submit that the city...
No, but here, okay.
Yes.
The records show a repavement in November 2019. Your guy says he was hurt in March 2021. That's not a month before. That wouldn't raise an issue of fact. That's like 2 years later.
Respectfully, I'm not aware of a hard and fast rule that 1 month
Okay.
is okay and 1 year is not okay.
Well, I would say that that's pretty obvious, that an immediate situation might come up under a month, but clearly couldn't come up if it happened 2 years later.
3.5.
Right, 3.5, right?
A year and 3.5 months. That's right.
Can I ask you, let's take what you're saying to be true for the time being. I don't understand how this particular 2-inch deep and about a foot wide depression is a causal connection between what the city did.
And you can answer.
I'm sorry.
No need to apologize. You can answer.
I'll quickly answer. The expert, the engineer, he said that the violation of multiple rules there, the highway rules, included the slope, that there was an improper slope, a max transverse slope.
That would mean the entire stretch would be bad, right?
Correct. And that's what he
So this
observed.
particular spot, how is it isolated to that spot where she fell?
Well, he says that the whole roadway was
He fell, excuse
defectively worked on, that there was an improper wearing course installation in violation of Section 211E12I, and that the standard of details of construction required a standard transverse max slope of 1/2 inch per foot, which this wasn't. So the entire width of the roadway, there was no continuous slope. And when he went to inspect it, he saw multiple potholes, patched, repatched, unpatched, including the subject pothole, which he saw was patched at that time.
Thank you, counsel.
Thank you.
Good afternoon. Alex Famelli for the city. I'll be as brief as you're hoping I will be.
Counsel?
Yes.
Just briefly, have you had a chance to read that Martin versus City of New York case?
I have.
And I was a part of the panel, and I remember that case, and in that case, there was a defect immediately upon whoever worked on that area
Exactly.
having finished the paving. And the only issue was whether it was the city or whether it was someone else.
The gap of a month that my friend refers to is the gap between the repair by the city and also the alleged observation of the defect and when the injury took place.
So they saw the defect immediately upon the repair.
That is what the
The
plaintiff
injury
alleged.
took place a month later.
Exactly.
That's the difference.
Yes.
Whereas here, we don't know when the defect was created.
Exactly, Your Honor. And it's, Yarborough, Bielecki, all of these other cases we cite establish this rule. The most specific the expert here gets is to say that the work was inferior and that it caused the roadway to become uneven and depressed.
And we don't know
15 or
when
so-
that happened.
We don't know when that happened. And absent evidence suggesting when it did, I'd urge the court to affirm the grant of summary judgment. Thank you.
Thank you.
Just very quickly on that Martin v. City case. In there, just as over here, there was nothing on the record to indicate when the dangerous condition developed. That's what that case says. And it was undisputed that the work was done, just as here. Over there, it happened 1 month before, and there was dispute as to whether the city did it or someone else. There's no dispute here. It's undisputed here that the city did work 1 year and some change before the accident. The question is, if there's an inference to be made, if there's two inferences, whether it happened right away or it happened sometime later, that should have been construed in plaintiff's favor. In the appellant's
So let me read to you from the decision in Martin. And this I am reading from page 4 of the decision. And it says, this is, now they're deposing the plaintiff. When shown photographs, and this is Judge Renwick writing, when shown photographs where his accident occurred, he stated that he fell on a square blacktop that contained loose gravel and was raised about 1.5 inches. He had noticed the condition about a month before the accident when pavement work had been done. Although he did not see who did the road work, his girlfriend told him that the city had performed the work. So they know he noticed when the pavement work was done that there was a defect.
Correct.
According to what he said.
That's right. But over here, we've submitted photographs that the plaintiff testified were taken the day after the accident, contemporaneous, day after the accident. And they showed the defect that he testified caused him to.
But what about the day after the paving of the roadway? Did anybody see any condition the day after the road was paved? Do we have any information on that?
No, we don't.
That's the difference between Martin and this case.
Respectfully, I didn't read Martin to say that it was 1 month was enough.
That's not what I'm saying. What I'm saying is that when they paved in Martin, somebody noticed that they left a defective condition, whereas when they paved here, you have no one to say that when they did the paving, they created a defective condition.
Well,
and what your expert said was that they used inferior roadway work, which caused the defect, and we don't know when the defect was caused, whether it was immediately upon the paving or sometime thereafter. If it occurred sometime thereafter, then you needed to have had some type of notice, that the city was on some type of notice, prior written notice.
the only thing
You don't have that.
The only thing I'll say to that is that the fact that they violated their own mandatory resurfacing standards, which is what the engineer said, they left behind a defective roadway, and that caused the defect.
Thank
And
you,
if there's nothing further, I'll rest on my brief. Thank you.
Carvello versus Warner Music Group.
Your Honors, Lyle Zurkin for Warner Music Group Corp. and Atlantic Recording Corp., the defendant appellants. I'd like to introduce my partner, Peter Anderson, distinguished member of the Bar of the State of California. He has been granted permission to appear pro hoc vice in this case, and I respectfully request that he be permitted to argue the appeal as well.
Welcome. What a day. 20 degrees. What's the weather in California?
Well, actually, when I woke up this morning, it was 17 degrees here. When I left Los Angeles 3 days ago, it was 79. But I'm trying to really enjoy the snow. I haven't seen snow for quite a while. So
Okay.
and thank you for the honor of allowing me to argue today. The plaintiff's claims go back to the late 1980s and early 1990s. Warner Music Group Corp. was not formed until 2003. So plaintiff tries to keep Warner Music Group Corp. In the case by relying on a successor liability argument. It's actually just a conclusion. Plaintiff alleges in her complaint that Warner Music Group is the parent of Atlantic and that it succeeded.
What proof do you have that somehow, not only that they succeeded, but that they didn't purchase it, or that somehow it is the de facto basically corporation?
Yeah, those are some of the Schumacher bases for finding liability if one corporation acquires another. But it's a little bit backwards here because the plaintiff has to allege facts establishing successor liability. The plaintiff...
What case says that? Because I know you talk about Schumacher, but that's a summary judgment motion. You know, this is 3211, and we all know the standard, so there's no need for me to repeat it. So why is Schumacher applicable, that summary judgment, and what appellate case says, you know, you need this heightened standard?
Well, on page 38 of our opening brief, we cite, I think it's 4, maybe 3 cases that sustained a motion or granted a motion to dismiss where the plaintiff alleged only that a defendant was a successor to another defendant that it had acquired. Plaintiff here alleges even less than that because they goofed the language. They actually say that Warner Music Group succeeded to the liabilities of Atlantic's parents and affiliates, which isn't, we've read that, you know, generously to take it as an allegation that Warner Music Group succeeded to the liabilities of Atlantic.
I mean, that's a good enough allegation, right? So now you say, well, we didn't exist at the time. So what? If you purchased the assets and the liabilities, then did you put in documents that show that you didn't accept any of the liabilities of the predecessor corporation?
As a little bit of background, and this
I'm just asking you, but yes, I want to hear what you have to say, but I first just want me to answer the question. Did you put in any documents that show that, because plenty of times successors take on the liabilities and of the prior corporation. So did you put in any documents like that?
I believe it's in 167 in the docket of the trial court, we submitted SEC filings of the transaction.
In the record before us?
It's not in the excerpt of record. There's a reference to it.
It's not in the record before us. We can't consider it, counsel.
So what we have then is we have a bare conclusion that Warner Music Group succeeded to Atlantic, and we put in, and it's in the transcript of, on appeal, we put in the articles of incorporation.
Yeah, but that doesn't prove that you didn't take the liabilities when you took the assets. That's the point. And we're a notice pleading state, right?
Yeah.
They're giving you notice. This is what my argument is, that you didn't do it. Now, you've moved to dismiss under 3211A7, which says you haven't stated a claim. They have stated a claim. They said you took over the liabilities of the predecessor corporation, and therefore, on that basis, you're liable. If you wanted to dispute it, it was your obligation under 3211A1 to put in enough documents to show us that as a matter of law, that wasn't true. You may have those documents, but you didn't put them in.
Well, let me just add one thing and I'll move on. In Rogue, which is a sister case, we actually did put in those documents.
You did. That's not before us today.
But the court can look at that decision.
No.
All we need to do is look at the record in front of us.
Okay.
You didn't put it in. We're not going to look at it.
Okay, then thank you, Your Honors. I'll turn to the respondeat superior argument or issue. And the case law is absolutely clear that respondeat superior liability does not extend to the sexual misconduct of employees. That is exactly what's alleged here. Respectfully, the lower court erred by finding that there was some kind of enabling of this conduct by the parent, by the employer, excuse me. But the court cited to a different statute, the state and city human rights law, which is different. That claim was never made in this case. This is a common law claim for battery, assault, sexual misconduct.
Would they be able to assert such a claim?
They're very experienced employment lawyers. I'm sure they didn't assert it for a reason.
Thank you.
Good afternoon, Your Honors. Cameron Moxley from Brown Rudnick for the respondent, Ms. Carvello. And I'll just note for the court that Ms. Carvello was in the courtroom today. Your Honors, let's start with being clear-eyed. I think this court is, but I'll just start there with what this case is, where this case is in its procedural posture. We are on a motion to dismiss. All that matters at this point is whether or not the complaint states a cause of action. With respect to what the ASA, the Adult Survivors Act, revived, the corporate defendant's argument they are not liable for intentional tort claims Ms. Carvello asserts against them fundamentally misapprehends what the ASA is and what it revives. The starting point always is with the statutory language itself. And
I'm not sure what you mean by that. What do you mean? You think that a new cause of action was created? Because it wasn't.
It definitely was not. I agree with that, Justice
So
Scalia.
you're claiming you're reasserting common law claims, right? And your common law claims are for intentional torts, correct?
Yes, we have both intentional and negligent.
And you're asserting them against Warner on a theory of respondeat superior.
No, Your Honor, we're asserting them against Atlantic Records on a theory.
Sorry,
On two theories, Judge. Respondeat superior is one theory. Another theory is our ninth cause of action, which is for negligent supervision, hiring, retention, and failure to provide a safe working environment. Those two theories are independent theories of liability, both of which were revived by the ASA because, and I'll go back to the statutory language, which is at CPLR section 214J, what's revived is every civil claim or cause of action brought against any party alleging intentional or negligent acts or omissions by a person that cause physical, psychological, or other injury or condition suffered as a result of conduct which would fall within the defined terms of Penal Law Section Article 130. Those are revived. Judge, our point simply is that the purpose of the ASA, as we briefed it, is to allow survivors to seek redress against both the perpetrator of the sexual assault itself, as well as any defendant who enabled the sexual assault.
But the point is, the claims that you've alleged are not eligible under a theory of respondeat. There might be other claims that you can allege under the Adult Survivor Act, but the ones that you've alleged, respondeat superior is not available to you. And the ASA didn't make something available to you that wasn't available before.
Justice Scarpello, we completely agree that the ASA didn't revive something that wasn't already there. But we disagree, Your Honor, respectfully, that respondeat superior is unavailable here. And Justice Rosado at Supreme Court actually has this right. If you look at the case law,
we've all looked at the case law. You cannot, under a theory of respondeat superior, be liable for an intentional act of your employee that isn't part of their employment.
That's right. That's right. But here, Judge, what happened is you have all the complaints allegations reflect that the company itself condoned and encouraged the intentional act. The intentional acts here were carried out by the apex of the corporation. Mr. Erdogan was its founder and chairman. Mr. Morse was its
My
president.
question to you is, are you saying that there's no facts that are saying that this is the part of this defendant's job duties, is to go harass women? That's what you have to look at. And that's, again, you might have other claims. We're talking about respondeat superior for intentional torts like sexual assault, right? And the case law is clear that if it's not part of your job duties to sexually assault someone, I mean, in so many contexts it's clear, you cannot have a respondeat superior claim. You might have other claims, you might have negligent hiring claims, but you can't have a respondeat superior claim.
Respectfully, Your Honor, I will disagree and point
So
you to.
we'll
let
just
me
have
point
to
you to authority.
disagree.
Just let me point you to authority. I'll point you to authority, though. I would encourage the court to consider McGrath versus Nassau.
Well, how about, I'll give you some too. Judith M. versus Sisters of Charity Hospital, Taylor versus United Parcel Service, Bowman versus State,
I understand, Judge, but if I may just make a point really quickly. What does within the scope of the tortfeasor's employment mean? What McGrath says it means. This is a 2002 case from the Eastern District of New York interpreting New York law. What it means is an employee's conduct is, quote, within the scope of his employment if the employer could have reasonably foreseen the employee's tortious conduct.
Are we bound by anything that the Eastern District of New York says?
No.
And
Your Honor.
our law says something different.
No,
right?
but well, respectfully, Judge, that
I
is.
think our law is a little different than that. New York State cases.
Thank you.
But on the other, let me go back to your claim of negligent hiring.
Yes, Judge.
What cause of action was that?
That's our 9th cause of action, Your Honor.
Okay, and okay.
I see my time is up.
Yeah.
I'm happy to answer the question if there is a question.
No, I just, okay, let me make it.
Thank you, Your Honors.
The ASA also didn't change, of course, didn't change existing common law, which is extensive as to the limitations on.
Well, let me ask you about the negligent hiring claim.
And that's exactly what I was going to turn to. The ASA also did not change workers' comp exclusivity. This is an employee suing Atlantic for negligent hiring, for negligently allowing these alleged things to happen. It's squarely within the workers' comp exclusivity, and that was another error on the lower court. They should have dismissed that.
No, but
All the
how is
negligence-based claims.
that, no, but against Warner or Atlantic for negligent hiring, that doesn't apply. The workers' comp doesn't apply.
Atlantic is the employer.
Right.
That's what's alleged. So the workers' comp exclusivity applies to Atlantic. Warner did not even exist.
Atlantic, the claim is Atlantic negligently hired the guys who.
Yes.
And why is that covered by workers' comp?
Because the exclusive remedy for negligent conduct by an employer, an employee's exclusive remedy, and plaintiff was an employee, she alleges that. The exclusive remedy for an employee of a negligent-based claim against an employer is workers' comp.
No, there are you can have a claim for negligent hiring. Oh, you're saying as the employee themselves, okay.
Yes, and almost all the cases that the plaintiff cites are cases where there wasn't a workers'
Right, it's
comp
a third
issue.
party who said, I got it. I just didn't see it for a moment, okay.
No worries at all. So respectfully, we would ask that the court reverse the lower court. The claims are based on responding at superior, which can't, on the face of the complaint, happen. It's an amended complaint, by the way. So, and then the workers' comp issue bars the negligence-based claims.
Thank you.
Thank you, Your Honor. Thank you again for the privilege.
All right, the second Carvello v. Warner Music Group case.
May it please the court, my name is Jeffrey Movitt, and I am here for defendant appellant Jason Flom. Each of the three claims that the trial court declined to dismiss should have been dismissed, and it was an error of law not to. In analyzing these claims, it's critical, first of all, to look at who Mr. Flom was at the time. Mr. Flom, just like
Co-worker, right?
I'm sorry, you're
Co-worker?
Co-worker, correct. That they were both, Ms. Carvello and Mr. Flom both were entry-level employees, and during the relevant time period of 87 to 90, they both were promoted to be junior executives.
Was he her supervisor?
There is an allegation, albeit a false one, but we have to assume it to be true for purposes of this motion, solely with respect to the quote, honey, sit on my lap statement, that he was her supervisor at that time. There is zero allegation that he was their supervisor at any other time in it. And so, as was previously said in the last argument, Mr. Erdogan and Mr. Morris, who are alleged to have directly committed acts of sexual, physical misconduct and battery, were at the very apex of this company, while Mr. Flom was a junior executive.
So there was nothing he could do about them.
Right?
Not at this time, Your Honor. He was...
At the time of plaintiff's employment, I thought he was.
He was a junior executive,
I don't
and
know what that means. Was he a vice president in the A&R department?
I think that's alleged. But with that said, Mr. Erdogan and Mr. Morris were at the very top of the company. Yeah. And so there's only two allegations here upon which the claims against Mr. Flom are premised. One is that he allegedly twice said, "Honey, come sit on my lap" at a meeting. And the second is that he purportedly did not intervene to stop Mr. Erdogan and Mr. Morris from allegedly engaging in misconduct. The three claims that the court allowed to proceed are negligent infliction of emotional distress, intentional infliction of emotional distress, and conspiracy to commit intentional infliction of emotional distress. Now, the principal basis that the court below declined to dismiss the negligent infliction of emotional distress claim based on the workers' compensation exclusion was a clear error of law. The lower court said, without citing to anything, that a coworker cannot invoke the workers' compensation exception. That's completely incorrect, as the First Department held just last year, when it held that the workers' compensation law bars a tort action against an allegedly negligent co-employee. So that is a clear error of law. The other ground that the trial court held for declining to apply the workers' compensation exception was that the trial court claimed that there's a purported exception to the workers' comp exemption for tortious conduct, quote, instigated by an employer through a culture of encouragement and unaccountability, close quote. First of all, Mr. Flom was not the employer of Ms. Carvello, so even if this was a legitimate exception, it wouldn't apply. But this is a non-existent exception. It does not exist under the law. The only case that the lower court cited for this purported exception is Martinez v. Canteen Vending from the First Department in 2005. What the court actually held in Martinez was that the plaintiff's negligent claim was barred by workers' comp exception. So this case says the exact opposite of what the lower court said it says. The lower court apparently focused on some dicta in the case that talked about intentional torts, but here we're talking about negligent infliction. We're not talking about intentional infliction yet. So that exception that the court held simply does not exist. Now, realizing that these are presumably defective grounds, the plaintiff in her respondent's brief argues that the workers' compensation exception should not apply because being allegedly sexually harassed was, quote, not part of Ms. Carvello's job description, close quote. But that is not the standard that's applied in New York. And as the Court of Appeals held in 2024 in the Tim Piero v. Bronx Lebanon Hospital, when an injury arises in the course of a worker's employment, it is presumed to arise out of that worker's employment. Now, in the Tim Piero case, it's a horrific set of facts. There was a mass shooting at the workplace. And the court said that, and the gentleman that sued, thank God, didn't die, but he was injured. And he had a negligence theory against the employer. And the Court of Appeals said, this arises out of the employment.
Thank you, counsel. Thank you.
Thank you, Your Honors. Cameron Moxley again for the respondent. If I may just start with the workers' compensation issue. Workers' compensation is not a bar to Ms. Carvello's claims because her claims do not arise from the natural consequence of her employment duties. The Lemon case says that specifically, that that's a requirement. For such injury to occur in the course of employment, the employee must have been doing work for which she was employed. The emotional distress that Ms. Carvello suffered was not a natural consequence of her duties. Being harmed in the way that she was, according to the allegations of the complaint, was not part of her job. Just to take one step back, let me just draw your attention to Mr.
But that's
Flum's.
true of any injury. It's never a part of your job to get injured, so that can't be the standard.
Your Honor, I would respectfully point you to
Never a part of your job to slip on ice in front of the building that you're working in, or to get hit by a chisel that falls on your head. That's never part of your job, so that can't be right.
No, it is right, Your Honor, respectfully, because the statement of law in Mr. Flum's brief, at page 9 of his reply brief, is, quote, accidents arising in the course of employment are presumed to arise out of such employment and fall within workers' comp. There is no reading of Ms. Carvello's complaint that suggests any of the tortious acts she's talking about are quote-unquote accidents. These are outside of the natural consequence of her, just as Justice Rosado concluded. These are outside of that. So workers' compensation is not a bar because of that. And think about the death knell that it would cause to the ASA and legislative intent in this state if this
One second, what about if, let me go a little step forward. I come to work one day, I have a fight with my coworker and they slap me in the face. We felt that that's covered by workers' comp, right? It's not a natural consequence of my job to come in, have a fight with my coworker and get slapped in my face, but that's a workers' comp claim.
No, but here the company could have reasonably foreseen that this sexual misconduct, these sexual assaults would have occurred.
People argue that they shouldn't have hired, all those things. They could have reasonably seen that these two workers were having a beef for months and months and months that wound up were coming into a fight. That's still covered by the workers' comp law.
Not if it falls outside of the natural consequences arising from the employment. Okay. Respectfully, Your Honor. And then let me just make one more point with respect to specifically to Mr. Flom's arguments with respect to the negligent and intentional infliction of emotional distress. Justice Rosado's decision below read the complaint in its totality and understood the following sequence of events. Number one, he was her direct boss at the meeting. That's in paragraph 24 of the complaint. That's alleged in paragraph 24 of the complaint. That allegation, the court below read correctly, has to be considered in the context of Mr. Flom, as alleged in the complaint, being present for two violent sexual assaults as alleged in the complaint previously, prior to that meeting. So according to the complaint, prior to the meeting, Flom is present at two violent sexual assaults, does nothing, is alleged to laugh and to ignore the sexual assault that is occurring during those times, and then subsequently, while alleged to be her direct boss at the meeting, says to her in front of the room, causing the room to laugh, "Honey, come sit on my lap." And he says it not once but twice, making it crystal clear that she wasn't allowed to participate in the meeting unless she sat on his lap. Excuse me, Your Honors, I don't mean to be to get so emotional, but that is the basis for the emotional distress tort, and whether it was intentional or negligent, that is a cognizable claim that was revived by the ASA because, as Justice Rosado found, Article 130 predicate sexual assault is part of the complaint. Mr. Flom saw it, did nothing, and then engaged in that behavior. That's egregious behavior that's actionable, Your Honors.
Can I ask you, what duty did Mr. Flom have to your client?
Well, Mr. Flom was her direct boss at the time.
What's the duty?
Yes, I think he had a duty, just like management does, as our negligent supervision, retention, and hiring allegations set forth, Justice Hagler, that they have a duty to provide a safe work environment. He didn't provide the safe work environment. Now, we're not saying, Justice Hagler, I want to be clear, this court does not have to find that he had a duty to intervene in the assaults to affirm the court below. This court does not have to find that. We're not asking the court to find that. What we are saying is that he had a duty not to engage in the conduct that he's alleged to have engaged in at that meeting, particularly after he was present for the Article 130 sexual assaults that he witnessed.
That is something that he should not have done, whether he had seen someone else sexually assaulting this plaintiff or not.
Justice Mendez, I completely agree. The reason we're tying it to that is simply so that it's clear that it's revived, because we have to tie it to the Article 130 to have it revived. And so that's the point of that, Justice Mendez.
Thank you.
Thank you, Count. Thank you.
So I think that the plaintiff's counsel just conceded that this torture theory of IIED is trying to tie something to the criminal Section 130 that cannot be tied to it. What this is a claim for hostile work environment. However, that's not alleged. And the case law is very clear that you can't repackage a defective hostile work environment claim into IIED, case after case after case. What the law says, and it's in our reply, is you can only do that if the defendant himself or herself is alleged to have committed a battery. That did not happen here, unquestionably. Mr. Flom did not commit a battery, and the cases could not be more clear. You can't turn hostile work environment into IIED. It's not a catch-all to fix defective claims. Also, we don't think that the honey was sitting in my lap. Well, it's something that's definitely not good and not.
It's totally inappropriate.
Yes, he didn't say it, but it's an inappropriate bad thing to say.
The allegation is.
Yeah, the allegation, absolutely. It's not up to the standard of IIED. There's cases with horrific racial slurs, and it's not IIED. So under precedent, it just doesn't satisfy it. Finally, the conspiracy it's just completely conclusory. Who agreed what, when? As this court's discussed earlier today, this is a notice pleading jurisdiction. This catch-all of conspiracy doesn't give my client notice of anything. And for that reason, it should fail as well. There's case after case after case saying that bare legal conclusions do not survive 3211, and that's all we have here. And if the IIED is dismissed as it should be, then the conspiracy to commit IIED would fail in any event. If the panel has any questions, I'd be happy to hear them.
All right.
Thank you, Your Honors.
Board of Managers versus 56 and Park.
Good afternoon. Glenn Lenahan with Oved and Oved on behalf of plaintiff appellants. This appeal arises out of the lower court's error in denying plaintiff appellants' motion for leave to amend to add fraud claims against the 3 respondents in the lower action. The court denied it for one reason and one reason alone, in holding that there is no prejudice to plaintiffs' appellants who can assert these claims in a separate action, while the procedural posture of this case is such that allowing the amendment now would seriously prejudice the more peripheral defendants.
So is there any evidence that if we allowed the third amendment to the third motion to amend the complaint, that would affect, that would harm the peripheral defendants whose claims are probably not essentially in the midst of this part of it?
Yeah, thank you, Your Honor. No, there's no evidence at all. And in fact, none of these peripheral defendants oppose the motion. The respondents that did oppose the motion didn't say anything about the peripheral defendants. And in fact, there can be no prejudice to the peripheral defendants against whom these claims are not asserted, because the only thing they could point to would say, we have to be in this case longer, which A, isn't necessarily true, which I'll get to in just a moment.
So they could move for summary judgment at this stage if there are no new claims against them?
They could move for summary judgment. The case against the the newly added claims against the respondents could be severed into a separate action, in which case the initial case would not change at all in terms of the timing. But more importantly, even if there would be delay, that's not prejudice. Prejudice exists where you lose the ability or an important ability to defend yourself. A witness has died, documents aren't around anymore. Prejudice is more than just, I have to stay in this case. This is from the Court of Appeals all the way down, and it's long been the law of the land in New York, where where leave to amend, rather, is freely given. These claims are well pled, there's no prejudice to the respondents, and the parties against whom that the court was concerned about didn't even make this argument. They didn't put in any papers, so there's nothing in the record to reflect that they could be prejudiced. And as I just explained, and as Your Honor pointed out, they would not be prejudiced even if they had made such an argument. In fact, as we showed that is in the record, these are the very defendants who sought and were granted a further extension of discovery. So they had already come to the court and asked for more time to complete. We moved for leave to amend, or rather filed a pre-motion letter pursuant to the court's rule, with 12 months before the note of issue deadline. There was plenty of time to allow this to go forward. There's very little additional discovery that's going to be needed. In fact, in the new case that was started, we prophylactically already served discovery demands, most of which, I'd say upwards of 95%, we're expecting to hear everything's already been produced. Of course, to protect our clients, we have to serve these demands. But the point is, this case can move forward quickly, and the initial case here could have moved forward quickly. These claims of prejudice are not only not supported by anything, but
Second,
literally no
you
one made that
brought
argument.
these new fraud claims in another action?
Well, we had to, Your Honor.
I know, I understand, but why don't you just stipulate to consolidate the two
Because
cases?
that's where, well, that's where the prejudice to our clients exists, Your Honor. Where the court found there's no prejudice to plaintiffs, unfortunately, the lower court erred. There is prejudice because we lose the benefit of the relation back
Oh,
doctrine.
but if you consolidate, you can argue, there's case law that says that you can argue relation back on a consolidated case.
I agree, Your Honor.
So what's the
Respectfully,
problem?
well, the court directed us to file this in a new action. The respondents, who are represented by zealous counsel doing their best to defend their clients, are not amenable to allowing us to consolidate.
Oh, and relate back? They want to still argue relation, okay, got it.
In the other case,
Well, that was, so then who would ever do that, right? You did it, I understand. I don't understand why they didn't agree to that, but okay.
we did what we had to do to protect our clients, and because
exactly.
there's no guarantee of anything. However, we do believe that the law is very much on our side on this appeal here, and that given the liberal standard and the lack of prejudice to anyone, and the fact that
Can I shift it a little bit? Why did it take so long for you to bring up these causes of action for fraud?
Sure. So we asserted claims regarding the defective facade in the original complaint. They were in the second amended complaint. We knew the facade was negligently constructed, but silly us, we didn't realize there was actually a fraud going back to 2013 when they knew it wasn't going to work as designed. They said the exact opposite in the offering plan.
When did you first learn that there was an allegation of fraud?
We learned about the fraud in the late fall, winter of 2024 when document productions came in from non-parties, and those non-parties were deposed, and we had the Rule 11F depositions, during which we learned that the sponsor, the architect, and the structural engineer disregarded the advice of every single consultant, 4 concrete consultants who said this wasn't going to work, fired them, bowled ahead with doing this, lied to the DOB to get a violation removed, which we only learned when the defendant WSP, who spoliated evidence, deleted all of its internal emails, gave us an email that showed that the supposed peer review firm that reviewed their report, that they said to the DOB, found that the design was in conformance with the governing rules, actually questioned the safety design. We got that email in December of 2024. We asked the court for leave to amend a few weeks later. So look, we got something like 8 million documents in November of 2023. Those documents, unfortunately, didn't have a folder said fraud. We had to go through all of them. We had to take depositions to understand, and most importantly, we needed these non-party documents and depositions to put together and realize this is a fraud. If we tried to plead this earlier...
Are you saying that it was otherwise reasonable to do it in the time frame that you did it?
That is a much more succinct way of saying it, Your Honor, yes.
Thank you, counsel. Thank you.
Good afternoon, Your Honors. Ronald Greenberg for Respondent 56th and Park, New York, owner LLC. I almost don't know where to start, but I know where I'd like to start, which is the issue on the appeal here is unpreserved. It was never raised below, and they admit that it was never raised below. Nor was it decided sua sponte, and it is certainly not a pure legal issue presented on the face of the record that could not have been avoided had it been raised. That's because, Your Honors, what they needed to show on leave to amend is that there would not be prejudice to the non-moving parties. That's not the basis for their issue.
Non-moving parties didn't even object.
No, Your Honor. Every argument that applied to the non-moving parties who are, and let me...
Can you show me in the record where there's opposition from the non-moving parties?
No, Judge, the non-moving parties, well, we were the non-moving parties, so...
I apologize. The other non-moving parties, I should have said it that way.
Non-responding parties. You responded.
Yeah, there's 40, let's talk about this case for a second and the realities of it. There's 40 parties in this case. There are...
We know the case. Here's what I want to know. Why leave to amend is freely granted? We start with that, right? Always. Could be on appeal, could be after verdict. Freely granted. You have to show that you would be prejudiced. You have to show that you would be prejudiced by the amendment. Otherwise, it's granted. That's what the law is. So let's start with you. What's your prejudice?
Your Honor, this case had been going on for 4 years.
Other than time that it's been going on, what's the prejudice?
If I could
Yeah.
continue, because it's not just time.
Okay.
4 years, 7 million pages of documents produced, 100 days of deposition testimony, experts, all of the rest, all of it devoted to a pleading that was 1,200 defects, $100 million, a breach of contract case.
It's a big case.
But it's a big breach of contract case.
And negligence and
No.
all kinds of other stuff. Well, there are third-party actions, right? Not the main action.
Not the main case. It's a breach of contract case that we've been litigating.
And breach of fiduciary duty. The main case is
The main
breach of
case,
contract?
you asked me, my client.
Right.
The
No,
only claim-
okay, just against your client. So go ahead.
My client is a breach of contract case. They defended it for 4 years. They substituted in year 3. Had these documents in year 2, by the way, all of them. This complaint, in response, Justice Hagler, to your question before, their complaint, 57 documents, 57. This is not a murder mystery. This is a construction litigation. Everything is in the documents. They had them for 2 years, all in their pleading. New counsel comes in, decide they want to bring a fraud case. We've been litigating a breach of contract case for years. At the 13th hour, they come in and say, now, full stop, this is no longer the 1,200 defect case.
What if that's when they found out about the fraud? Then what are they to
The
do?
fraud was all in the document. I understand he's saying, oh, we asked a question at a deposition. The questions at the deposition were, does this document say this? Does this document say that?
Counsel, fraud requires some sort of intent. Wouldn't they need to go to a deposition to at least explore the documents? You're saying they should add it without, you would prefer a fraud claim without a basis in law?
I'm only referring to their pleading. Their pleading that alleges fraud is not based on this deposition testimony. It's in the record. We can all read it. It cites chapter and verse. This document said that.
Even so, what would your prejudice be if the fraud was conducted? Then your client obviously would know beforehand, whether it's in 2013, 2015, 2024, it doesn't matter.
Well, there's several answers. One is we've been litigating a contract case.
Besides time, my colleague talked about time. Let's talk about anything but time. Don't talk about time.
Well, it's starting the case all over again. He says, oh, well, we had all the discovery already. They just served a document request, 118 categories of documents. The whole case is starting from scratch.
Counsel also said you've already produced 95% of that, and you wouldn't consent to a consolidation so that you could use the documents in both cases, and that's your privilege. But let's assume, so what you're saying is that they knew about the fraud years ago, right? So that is a motion to dismiss for on statute of limitations grounds. We're not down the road there. The question is, given our state's free amendment of pleadings, why we shouldn't allow that here.
Because, and Justice Crane knew well about the pleading standard and how lenient it is. But what this court has said a couple of years ago with Justice Kennedy on the panel, and I'm quoting from it, Pecora v. Pecora, that a note of issue had not been filed in this action is of no moment, as we've required an excuse for shorter delays regardless of a notice of issue being filed. That was a case where no note of issue was filed, and it was based on the delay to the parties. And I've told you about the prejudice to my client, starting a new case from scratch. But what I was talking about before is the reality of this case with these 40 contractors. And we had Andrew Peck, Judge Peck, the former magistrate judge, who was helping us with these discovery disputes for years. And these parties are getting run over because the major parties are having a fight. They're small guys, there's 40 of them. They're not briefing everything. Our brief covered the prejudice to everyone. There was no reason, there's no moment that they didn't put in a brief and say, yeah, what he says.
Thank you.
May I just, I was unable to really, and I get why, and I'm delighted to answer questions.
30 seconds.
But I really was not permitted to talk about the failure to preserve here. These arguments are absolutely unpreserved. They were never argued. They admit that it's unpreserved. They admit, however, that they never raised it. What they say is it should be heard because of narrow exceptions, that it was decided by the judge sua sponte, it wasn't, or that, and I'm taking from their brief, that it's a pure legal issue presented on the face of the record that could not have been avoided had it been raised.
Thank you, counsel. I'm ready to hear the next argument. Thank you.
Good afternoon. My name is Lauren Donnelly. I represent SLCE Architects. Leave to amend should have been denied because the amendments are palpably insufficient and patently devoid of merit as it relates to SLCE. Plaintiff's fraud theory is not based on new facts, but flows from the offering plan and its amendments, which plaintiff has had in their possession for 10 years. How can they not?
Well, I don't understand how a fraud claim could flow solely from an offering plan. It has to flow from an offering plan and something that is contradictory to the offering plan. So just saying they had the offering plan for years doesn't establish when they knew that there was fraud.
They are basing the claims against SLCEs based on certifications and statements made in that particular offering plan. Now, if you look at those statements—
Based on subsequent events or subsequent discoveries.
It's not subsequent. They've had all the information relating to the water infiltration and the facade problems from when the original complaint was filed. They had the offering plan at least 6 or 7 years before the original.
That doesn't mean that the claim isn't good. Your argument is the claim is barred by the statute of limitations. That's a different argument, and you can make that motion in a motion to dismiss the fraud claim. That doesn't mean that they haven't adequately pled a claim.
However, this is a motion to amend, and a motion to amend—
It's supposed to be freely granted, and assuming without deciding that they've said, we discovered this last year. I don't know if that's true or not, but that is sufficient to get over the statute of limitations issues in a pleading, and it's up to you then to move to dismiss it on statute of limitations grounds. That's the way it goes. That's the way we normally do it.
However, courts do look at whether the amendment has merit, and in this particular case, it doesn't.
What you're saying is not that it doesn't have merit. You're saying that they knew about the claim a long time ago, and the reason why it doesn't have merit is on a statute of limitations ground.
Then let me
I am
explain.
saying to you that's not relevant to a motion to dismiss.
Okay, well, if you are looking at the particular allegations—
I mean, a motion to amend, I'm sorry.
Okay, if you look at the particular allegations, they are saying that there's a there was a change in the language of the offering plan. And they admit that it was not a material misrepresentation or was not material. How can that be an evidence of fraud? That's where it goes to the merit. And it may not be just the delay. And if you took my argument, I may be conflating things, but the predictions in an offering plan by an architect are not actionable fraud. This court has held that in the Waverly Place and Dragon Investments case. And so a non-material wording edit in an offering plan—
But let me just interrupt you for a second. The court below didn't rule on that ground.
But that is a—
And did you put that in your appellate brief?
We did put that in our appellate.
And did counsel, but I mean, there was no indication because she ruled on another ground, right? So,
yes.
So that would only get you back to the trial court to rule on that ground, right?
Yes, Your Honor. So in any case, in terms of the relation back, there's no unity of interest in terms of the statute of limitations. That also goes to the fact that this lacks merit.
And that's a motion to dismiss once the pleading is amended. You might be right. The plaintiff may not be able to take advantage of the relation back, but for sure now the plaintiff can't do it because the court's denied amendment.
I think for all of the reasons that were in the decision, the court did not abuse their discretion here. It was a provident exercise of judicial discretion, and therefore the order should be affirmed. Thank you.
Good afternoon, Your Honors. Jamie Nardiello from Zetlin and De Chiara for WSP. May it please the court. I will be brief. I realize that it's 5 o'clock. I just want to touch on a few points as it relates specifically to our client, WSP. The entirety of this fraud claim that's asserted against WSP is related to a letter that was prepared in 2016 and was sent from my client to the sponsor. The plaintiff's complaint pleads absolutely no reliance. And so as we raised to the lower court, and we did argue in our appellate brief, they cannot state a claim as to of fraud against WSP. And when a proposed amendment will be futile, as it is in this case, there's every reason, as the court appropriately did, to deny the amendment. Here, the allegation of fraud cannot stand because of the lack of reliance and the fact that
Reliance on what?
so they argue that the letter that WSP sent to the sponsor was somehow the fraud that damaged the plaintiffs. And there are a series of cases that we set forth in our brief that very clearly state that.
Well, it's not the letter, it's that you didn't disclose the letter, right? It's the omission of what was in the letter. Isn't that the fraud?
No, they're claiming that the fraud that we sent to the sponsor caused the sponsor to submit a similar letter to the Department of Buildings, which then caused the Department of Buildings.
You put a misrepresentation in your letter, and that caused the sponsor to talk to the DOB.
Exactly, Your Honor.
And the plaintiffs relied on the DOB granting the change, right? Or allowing you to do the white construction thing or whatever it was, and in reliance on the DOB saying it was okay. Isn't that the claim?
That is the claim, Your Honor. However,
I don't know why is that insufficient?
Because it's not sufficient reliance. So the Court of Appeals in Pasternak declined to extend the reliance element of fraud to include a claim based on the reliance of a third party. In that case, the fraudulent statements were made by a drug testing company to a plaintiff's employer, and the plaintiff's employer relied on those statements, and the plaintiffs were damaged. The court noted that a fraud claim requires the plaintiff to have relied upon a misrepresentation by a defendant to his or her detriment. There cannot be reliance here because plaintiffs can see that they did not see that letter, which obviously we dispute was fraudulent in any respect, until it was produced in discovery. They had no knowledge of it, so there could not be any reliance. Additionally, they do not properly allege scienter. They do not properly allege aiding and abetting fraud, which just contains a series of conclusory allegations, and their claims are similarly barred by the statute of limitations, which we do set forth in our brief.
Thank you.
There's just a few things that I need to correct. Sponsor's attorney has said that the argument was not raised below by anyone, but it also wasn't sua sponte. It has to be one of the two. And the record is very clear, no one made any arguments that the more peripheral downstream defendants were going to be prejudiced or that plaintiff appellants will not be prejudiced.
What about the sufficiency of the claim with respect to the party in 2013?
With respect to the offering plan in 2013 by the architect?
Right.
By the time the offering plan was amended in June of 2013, as alleged in the complaint, the architect, SLCE, along with sponsor, had been told by a bevy of consultants that the concrete facade.
How did you rely on that?
Because the
You have to have direct reliance.
Yes, the contract of sale for every unit incorporates the offering plan. The architect in the offering plan certified that the facade is designed to prevent water infiltration.
You're saying that letter says something else.
No. The letter has to do with WSP, the structural engineer.
That's the one that I'm talking about.
Oh, I'm sorry. So that letter that they drafted in 2016 to the DOB was to remove a violation for cracks in the facade. What WSP said in that letter that it wrote was the cracks are a natural occurrence and they're only cosmetic and they're superficial. What we found out at depositions in December of 2024 was that WSP never monitored the cracks. The only thing it did was drill a core hole, and it found out that the cracks were 10 inches deep.
How did you rely? I'm focusing on the
Yes,
reliance.
because it caused the DOB to remove the violation. The purchase agreement said, incorporated the offering plan, which said, go to the DOB to base your judgment on whether a purchase or not. If you go to the website in the DOB, there was no violation.
That's not real. It's the DOB has a claim for reliance.
The purchasers relied on the lack of the violation that they defrauded the DOB into removing. And we have case law in our briefs that shows this is in fact reliance, and it does state a fraud claim. You don't need to directly defraud someone. When you directly defraud someone that you know the plaintiff is going to rely upon, that is a fraud upon the plaintiff. The plaintiff if a purchaser goes to the DOB.
Talking like accountant cases?
No. I'm talking all kinds of regular cases. This isn't a negligent misrepresentation case, and we're not saying that it is. But when you are directed to go to the DOB website and you oh great, there's no violations on the building. That's fantastic. That's a lot different than going and saying, oh, there's violations for the facade. I want to inquire more about this. Maybe I'm not going to buy. But you never have that. You're relying on what the DOB said, and that was only removed from the DOB website based on a letter that was false, knowingly false when written, with the intent of removing that violation.
Thank you.
Thank you. I've never been here this late before.